the person acquires a security entitlement to the security pursuant to Section 8 to 501. b. A person acquires a financial asset, other than a security, or an interest therein, under this article, if the person acquires a security entitlement to the financial asset. c. A. 2. d. Unless the context shows that a different meaning is intended, a person who is required by other law, regulation, rule, or agreement to transfer, deliver, present, surrender, exchange, or otherwise put in the possession of another person a security or financial asset satisfies that requirement by causing the other person to acquire an interest in the security or financial asset pursuant to subsection A, or B. Now for the entitlement itself. See in the definition of entitlement holder it refers you to 8105. B. 2 or 3. 8 to 501. Securities account, acquisition of security entitlement from securities intermediary. A. Securities account means an account to which a financial asset is or may be credited in accordance with an agreement under which the person maintaining the account undertakes to treat the person for whom the account is maintained as entitled to exercise the rights that comprise the financial asset. B. Except as otherwise provided in subsections D and E, a person acquires a security entitlement if a securities intermediary 1. Indicates by book entry that a financial asset has been credited to the person's securities account. 2. Receives a financial asset from the person or acquires a financial asset for the person and, in either case, accepts it for credit to the person's securities account, or 3. Becomes obligated under other law, regulation, or rule to credit a financial asset to the person's securities account. C. If a condition of subsection B has been met, a person has a security entitlement even though the securities intermediary does not itself hold the financial asset. D. If a securities intermediary holds a financial asset for another person, and the financial asset is registered in the name of, payable to the order of, or specially indexed to the other person, and has not been indexed to the securities intermediary or in blank, the other person is treated as holding the financial asset directly rather than as having a security entitlement with respect to the financial asset. E. Issuance of a security is not establishment of a security entitlement. Now for those who think the bank is the entitlement holder. 8 to 503. Property interest of entitlement holder in financial asset held by securities intermediary. A. To the extent necessary for a securities intermediary to satisfy all security entitlements with respect to a particular financial asset, all interests in that financial asset held by the securities intermediary are held by the securities intermediary for the entitlement holders, are not property of the securities intermediary, and are not subject to claims of creditors of the securities intermediary, except as otherwise provided in Section 8 to 511. C. An entitlement holder's property interest with respect to a particular financial asset under subsection A may be enforced against the securities intermediary only by exercise of the entitlement holder's rights under Sections 8 to 505 through 8 to 508. D. An entitlement holder's property interest with respect to a particular financial asset under subsection A may be enforced against a purchaser of the financial asset or interest therein only if 1. Insolvency proceedings have been initiated by or against the securities intermediary. 2. The securities intermediary does not have sufficient interests in the financial asset to satisfy the security entitlements of all of its entitlement holders to that financial asset. 3. The securities intermediary violated its obligations under Section 8 to 504 by transferring the financial asset or interest therein to the purchaser, and 4. The purchaser is not protected under subsection E. The trustee or other liquidator, acting on behalf of all entitlement holders having security entitlements with respect to a particular financial asset, may recover the financial asset, or interest therein, from the purchaser. If the trustee or other liquidator elects not to pursue that right, an entitlement holder whose security entitlement remains unsatisfied has the right to recover its interest in the financial asset from the purchaser. E. An action based on the entitlement holder's property interest with respect to a particular financial asset under subsection A, whether framed in conversion, replace even, constructive trust, equitable lien, or other theory, may not be asserted against any purchaser of a financial asset or interest therein who gives value, obtains control, and does not act in collusion with the securities intermediary in violating the securities intermediary's obligations under Section 8 to 504. Also find now that the bank, securities intermediary, has duties with regard to the asset of another. 8 to 504. Duty of securities intermediary to maintain financial asset. A securities intermediary shall promptly obtain and thereafter maintain a financial asset in a quantity corresponding to the aggregate of all security entitlements it has established in favor of its entitlement holders with respect to that financial asset. The securities intermediary may maintain those financial assets directly or through one or more other securities intermediaries. B. Except to the extent otherwise agreed by its entitlement holder, a securities intermediary may not grant any security interests in a financial asset it is obligated to maintain pursuant to subsection A. C. A securities intermediary satisfies the duty in subsection A, if 1. The securities intermediary acts with respect to the duty as agreed upon by the entitlement holder and the securities intermediary, or 2. In the absence of agreement, the securities intermediary exercises due care in accordance with reasonable commercial standards to obtain and maintain the financial asset. Yeehaw! Now I got it. The bank cannot be an entitlement holder because all banks do is deal with others' assets. No matter if it is depositors, investors, or even shareholders. Now for the funniest part about finding this section. When I read this entire article from the ABBA book, a call was made to the Secretary of State UCC Unit for Michigan and Section 8 to 510 and 8 to 511 were asked for and requested sent by mail or fax. The UCC unit stated the sections below did not even exist. When an ABBA book from the ABBA was mentioned and the sections were there yet not on Michigan's website and asked for a copy again, they put the manager on the phone and after a start-over explanation to her she finally admitted the section does exist but is not published on the web. Remember earlier the topics called attachment and priority from above? Well, read this section from Article 8 now. 8 to 510. Rights of purchaser of security entitlement from entitlement holder. A. In a case not covered by the priority rules in Article 9 or the rules stated in subsection C, an action based on an adverse claim to a financial asset or security entitlement, whether framed in conversion, replace even, constructive trust, equitable lien, or other theory, may not be asserted against a person who purchases a security entitlement, or an interest therein, from an entitlement holder if the purchaser gives value, does not have notice of the adverse claim, and obtains control. B. If an adverse claim could not have been asserted against an entitlement holder under Section 8 to 502, the adverse claim cannot be asserted against a person who purchases a security entitlement, or an interest therein, from the entitlement holder. C. In a case not covered by the priority rules in Article 9, a purchaser for value of a security entitlement, or an interest therein, who obtains control has priority over a purchaser of a security entitlement, or an interest therein, who does not obtain control. Except as otherwise provided in subsection D, purchasers who have control rank according to priority in time of 1. The purchasers becoming the person for whom the securities account, in which the security entitlement is carried, is maintained, if the purchaser obtained control under Section 8-106, D, 1, see below for 8-106, D, 1. D. A securities intermediary as purchaser has priority over a conflicting purchaser who has control unless otherwise agreed by the securities intermediary. 8-106, D, 1. D. A purchaser has control of a security entitlement if 1. The purchaser becomes the entitlement holder, or C 8-501, B, 2, 3. 2. The securities intermediary has agreed that it will comply with entitlement orders originated by the purchaser without further consent by the entitlement holder, or 3. Another person has control of the security entitlement on behalf of the purchaser or, having previously acquired control of the security entitlement, acknowledges that it has control on behalf of the purchaser. 8 to 511. Priority among security interests and entitlement holders. A. Except as otherwise provided in subsections B, and C, if a securities intermediary does not have sufficient interests in a particular financial asset to satisfy both its obligations to entitlement holders who have security entitlements to that financial asset and its obligation to a creditor of the securities intermediary who has a security interest in that financial asset, the claims of entitlement holders, other than the creditor, have priority over the claim of the creditor. B. A claim of a creditor of a securities intermediary who has a security interest in a financial asset held by a securities intermediary has priority over claims of the securities intermediary's entitlement holders who have security entitlements with respect to that financial asset if the creditor has control over the financial asset. C. If a clearing corporation does not have sufficient financial assets to satisfy both its obligations to entitlement holders who have security entitlements with respect to a financial asset and its obligation to a creditor of the clearing corporation who has a security interest in that financial asset, the claim of the creditor has priority over the claims of entitlement holders. Now let's go back to Article 4 for a minute and see if 4 is the article of authority. What does it say regarding this transaction? 4 to 104, 8. Drawee means a person ordered in a draft to make payment, this is you. 4 to 208. Presentment warranties. A. If an unaccepted draft is presented to the drawee for payment or acceptance and the drawee pays or accepts the draft, I, the person obtaining payment or acceptance, at the time of presentment, and, 2, a previous transferor of the draft, at the time of transfer, warrant to the drawee that pays or accepts the draft in good faith that 1. The warrantor is, or was, at the time the warrantor transferred the draft, a person entitled to enforce the draft or authorized to obtain payment or acceptance of the draft on behalf of a person entitled to enforce the draft. 2. The draft has not been altered, and 3. The warrantor has no knowledge that the signature of the purported drawer of the draft is unauthorized. B. A drawee making payment may recover from a warrantor damages for breach of warranty equal to the amount paid by the drawee less the amount the drawee received or is entitled to receive from the drawer because of the payment. In addition, the drawee is entitled to compensation for expenses and loss of interest resulting from the breach. The right of the drawee to recover damages under this subsection is not affected by any failure of the drawee to exercise ordinary care in making payment. If the drawee accepts the draft, I. Breach of warranty is a defense to the obligation of the acceptor, and, 2, if the acceptor makes payment with respect to the draft, the acceptor is entitled to recover from a warrantor for breach of warranty the amount stated in this subsection. C. If a drawee asserts a claim for breach of warranty under subsection A, based on an unauthorized endorsement of the draft or an alteration of the draft, the warrantor may defend by proving that the endorsement is effective under Section 3 to 404 or 3 to 405 or the drawer is precluded under Section 3 to 406 or 4 to 406 from asserting against the drawee the unauthorized endorsement or alteration, 3 to 404 and 3 to 405 at bottom of section. Please read. D. If, I, a dishonored draft is presented for payment to the drawer or an indexer or, 2, any other item is presented for payment to a party obliged to pay the item, and the item is paid, the person obtaining payment and a prior transferor of the item warrant to the person making payment in good faith that the warrantor is, or was, at the time the warrantor transferred the item, a person entitled to enforce the item or authorized to obtain payment on behalf of a person entitled to enforce the item. The person making payment may recover from any warrantor for breach of warranty an amount equal to the amount paid plus expenses and loss of interest resulting from the breach. E. The warranties stated in subsections A and D cannot be disclaimed with respect to checks. Unless notice of a claim for breach of warranty is given to the warrantor within 30 days after the claimant has reason to know of the breach and the identity of the warrantor is discharged to the extent of any loss caused by the delay in giving notice of the claim. F. A cause of action for breach of warranty under this section accrues when the claimant has reason to know of the breach. 4 to 209. Encoding and retention warranties. A. A person who encodes information on or with respect to an item after issue warrants to any subsequent collecting bank and to the payer bank or other payer that the information is correctly encoded. If the customer of a depository bank encodes, that bank also makes the warranty. B. A person who undertakes to retain an item pursuant to an agreement for electronic presentment warrants to any subsequent collecting bank and to the payer bank or other payer that retention and presentment of the item comply with the agreement. If a customer of a depository bank undertakes to retain an item, that bank also makes this warranty. C. A person to whom warranties are made under this section and who took the item in good faith may recover from the warrantor as damages for breach of warranty an amount equal to the loss suffered as a result of the breach, plus expenses and loss of interest incurred as a result of the breach. 3 to 404. Impostors, fictitious payees. A. If an impostor, by use of the mails or otherwise, induces the issuer of an instrument to issue the instrument to the impostor, or to a person acting in concert with the impostor, by impersonating the payee of the instrument or a person authorized to act for the payee, an endorsement of the instrument by any person in the name of the payee is effective as the endorsement of the payee in favor of a person who, in good faith, pays the instrument or takes it for value or for collection. B. If, I, a person whose intent determines to whom an instrument is payable, section 3-110, a, or, b, does not intend the person identified as payee to have any interest in the instrument, or, 2, the person identified as payee of an instrument is a fictitious person. The following rules apply until the instrument is negotiated by special endorsement. 1. Any person in possession of the instrument is its holder. 2. An endorsement by any person in the name of the payee stated in the instrument is effective as the endorsement of the payee in favor of a person who, in good faith, pays the instrument or takes it for value or for collection. C. Under subsection A, or B, an endorsement is made in the name of a payee if I, it is made in a name substantially similar to that of the payee, or 2, the instrument, whether or not endorsed, is deposited in a depository bank to an account in a name substantially similar to that of the payee. D. With respect to an instrument to which subsection A, or B, applies, if a person paying the instrument or taking it for value or for collection fails to exercise ordinary care in paying or taking the instrument and that failure substantially contributes to loss resulting from payment of the instrument, the person bearing the loss may recover from the person failing to exercise ordinary care to the extent the failure to exercise ordinary care contributed to the loss. 3-405. Employer's responsibility for fraudulent endorsement by employee. A. In this section. 1. Employee includes an independent contractor and employee of an independent contractor retained by the employer. 2. Fraudulent endorsement means, I, in the case of an instrument payable to the employer, a forged endorsement purporting to be that of the employer, or, 2, in the case of an instrument with respect to which the employer is the issuer, a forged endorsement purporting to be that of the person identified as payee. 3. Responsibility with respect to instruments means authority, I, to sign or endorse instruments on behalf of the employer, 2, to process instruments received by the employer for bookkeeping purposes, for deposit to an account, or for other disposition, 3, to prepare or process instruments for issue in the name of the employer, 4, to supply information determining the names or addresses of payees of instruments to be issued in the name of the employer, v, to control the disposition of instruments to be issued in the name of the employer, or, 6, to act otherwise with respect to instruments in a responsible capacity. Responsibility does not include authority that merely allows an employee to have access to instruments or blank or incomplete instrument forms that are being stored or transported or are part of incoming or outgoing mail, or similar access. B. For the purpose of determining the rights and liabilities of a person who, in good faith, pays an instrument or takes it for value or for collection, if an employer entrusted an employee with responsibility with respect to the instrument and the employee or a person acting in concert with the employee makes a fraudulent endorsement of the instrument, the endorsement is effective as the endorsement of the person to whom the instrument is payable if it is made in the name of that person. If the person paying the instrument or taking it for value or for collection fails to exercise ordinary care in paying or taking the instrument and that failure substantially contributes to loss resulting from the fraud, the person bearing the loss may recover from the person failing to exercise ordinary care to the extent the failure to exercise ordinary care contributed to the loss. C. Under subsection B, an endorsement is made in the name of the person to whom an instrument is payable if, I, it is made in a name substantially similar to the name of that person, or 2, the instrument, whether or not endorsed, is deposited in a depository bank to an account in a name substantially similar to the name of that person. 8. Patents and trademarks. Common law trade names. The common law trademark, trade name, copyright topic is one that has obtained a wide variety of scrutiny as well as discredit. However, before getting into any details, please check the following and then read on in this chapter. Also make sure you really understand the birth certificate topic discussion in earlier chapters as well. United States Court of Appeals for the Ninth Circuit. In re. World Auxiliary Power Company, in re. World Aerotechnology Corporation, in re. Air Refrigeration Systems, Inc., Debtors, Aerocon Engineering Incorporated, No 00-16550 Appellant, DC No VCV 00-00571 WA Silicon Valley Bank, Advanced Opinion. Aerospace LLC, Airweld Incorporated, Michael Gilson, Merritt Wyden, World Auxiliary Power Company, World Aerotechnology Corporation, Air Refrigeration Incorporated. Appellees. Appeal from the United States District Court for the Northern District of California, William H. Alsup, District Judge, presiding, argued and submitted December 7, 2001, San Francisco, California. Filed September 11, 2002. Before, Melvin Brunetti, Andrew J. Kleinfeld and Sidney R. Thomas, Circuit Judges. Opinion by Judge Kleinfeld. Opinion. Kleinfeld, Circuit Judge. In this case we decide whether federal or state law governs priority of security interests in unregistered copyrights. Facts. Basically, this is a bankruptcy contest over unregistered copyrights between a bank that got a security interest in the copyrights from the owners and perfected it under state law, and a company that bought the copyrights from the bankruptcy trustees after the copyright owners went bankrupt. These simple facts are all that matters to the outcome of this case, although the details are complex. 3 affiliated California corporations: World Auxiliary Power, World Aerotechnology, and Air Refrigeration Systems designed and sold products for modifying airplanes. The FAA must approve modifications of civilian aircraft by issuing supplemental type certificates. The 3 companies owned copyrights in the drawings, technical manuals, blueprints, and computer software used to make the modifications. Some of these copyrighted materials were attached to the supplemental type certificates. The companies did not register their copyrights with the United States Copyright Office. The companies got financing from Silicon Valley Bank, one of the appellees in this case. 2 of the companies borrowed the money directly, the third guaranteed the loan. The security agreement, as is common, granted the bank a security interest in a broad array of presently owned and after acquired collateral. The security agreement covered all goods and equipment now owned or hereafter acquired, as well as inventory, contract rights, general intangibles, blueprints, drawings, computer programs, accounts receivable, patents, cash, bank deposits, and pretty much anything else the debtor owned or might be hereafter acquired. The security agreement and financing statement also covered ALL copyright rights, copyright applications, copyright registrations, and like protections in each work of authorship and derivative work thereof, whether published or unpublished, now owned or hereafter acquired. The bank perfected its security interest in the collateral, including the copyrights, pursuant to California's version of Article 9 of the Uniform Commercial Code, by filing UCC-1 financing statements with the California Secretary of State. The bank also took possession of the supplemental type certificates and the attached copyrighted materials. But the copyrights still weren't registered with the United States Copyright Office, and the bank did not record any document showing the transfer of a security interest with the Copyright Office. Subsequently, the 3 debtor companies filed simultaneous but separate bankruptcy proceedings. Their copyrights were among their major assets. Aerocon Engineering, one of their creditors, and the appellant in this case, wanted the copyrights. Aerocon was working on a venture with another company, Advanced Aerospace, and its president, Michael Gilson, and an officer and director, Merritt Wyden, all appellees in this case, to engineer and sell aircraft modifications using the debtor's designs. Their prospective venture faced a problem. Silicon Valley Bank claimed a security interest in the copyrights. To solve this problem, Aerocon worked out a deal with Gilson, Wyden, and a company named Eros Capital, not a party in this case, to buy the debtor's assets, including their copyrights, from the bankruptcy trustees along with the trustees' right to sue to avoid Silicon Valley Bank's security interest. Once Aerocon owned the copyrights, it planned to exercise the trustees' power to avoid Silicon Valley Bank's security interests so that the venture would own the copyrights free and clear. Conclusion. Regarding perfection and priority of security interests in unregistered copyrights, the California UCC has not stepped back in deference to federal law, and federal law has not preempted the UCC. Silicon Valley Bank has a perfected security interest in the debtor's unregistered copyrights, and Aerocon, standing in the bankruptcy trustees' shoes, cannot prevail against it. Bush disavows group tactics. A Republican legislators group speculates on Democrat Janet Reno's drinking habits and sexual orientation. By Steve Bouquet, Times staff writer, copyright St. Petersburg Times, April 5, 2002. Tallahassee. A new group called Americans for Jeb Bush, headed by a Republican state legislator, proclaims itself dedicated to re-electing Florida's governor. But the governor calls it a scam and took extraordinary steps Thursday to put the group out of business. In what may be a first in Florida politics, Bush will even seek to register 3 campaign slogans as trademarks, like Xerox, to stop unauthorized use of his name. The governor sent an email to 20,000 supporters statewide urging them to avoid the group. "We're going to do whatever we can to stop them," Bush said during a news conference. This may sound ridiculous, but I'm going to trademark my name, so I can sue them. It's just one of these scams that misrepresents my views and attacks my opponent, and it's not my campaign. I've disavowed it completely. Bush took dead aim at a group whose fundraising pitches speculate on Democrat Janet Reno's drinking habits and sexual orientation, and accuse her of going easy on drug dealers while she was state attorney in Miami-Dade in the 1970s and 80s. The letters were signed by the group's honorary chairman, State Representative Gus Barrero of Miami Beach. Bush sent a strongly worded letter to Barrero calling on him to repudiate the group. Barrero refused but said he hopes to meet with Bush today. This organization was formed to deliver the strongest grassroots organization ever seen in Dade County, and through our state, Barrero said. His name is not trademarked. Using his name in campaigns. I don't think you can stop that. The group's existence and Bush's aggressive efforts to crush it underscore the high stakes in a governor's race that has drawn national attention because its central figures are the president's brother and the nation's first female attorney general. Although he consistently leads every poll, including one taken 2 weeks ago for the St. Petersburg Times, Bush appears worried about a possible backlash against such tactics by moderate voters, who can be decisive in a competitive race. Ben Ginsberg, a Washington lawyer and outside counsel to the campaign, said he would file trademark applications to protect 3 campaign slogans: Bush Brogan 2002, Jeb Bush for Governor and Jeb. Ginsberg is no stranger to Florida politics. He helped shape George W. Bush's Florida legal strategy in the weeks after the 2000 presidential election, and advises Florida Republicans on redistricting. Thursday's filing was done to stop the unauthorized use of Bush's name under federal trademark laws, Ginsberg said. The use of a trademark name for commercial purposes is outside of First Amendment protection, he said. A proper name cannot be registered, but a name's commercial use can be restricted, Ginsberg said. These are gutter tactics of misuse of a name, as well as personal innuendo against people who are running for office, essentially by people who are just trying to make money off the governor's name, Ginsberg said. Barrero said he is not being paid. This is not about money, he said. But he said the first fundraising letter, dated March 22, brought in $75,000 in less than 3 weeks. The results are so promising, Barrero said. He hopes to use the fundraising base to help fellow Miami-Dade lawmaker, Republican Representative Gaston Cantens, in his campaign to be House Speaker. Americans for Jeb Bush, based in Miami, is backed partly by Mark Goodrich, a conservative political activist and fundraiser who worked on Rick Lazio's unsuccessful 2000 U.S. Senate campaign against Hillary Rodham Clinton. The group's website resembles a campaign operation, with a logo of the U.S. flag, a portrait of the smiling Bush family, and a link to the official Bush Brogan site. The group's fundraising letter was upfront about its main message: stop Janet Reno and re-elect Jeb. Attached was a reprint of an article in Insight magazine, which is affiliated with the Washington Times and owned by the Reverend Sun Myung Moon's Unification Church. Also included, a photo of former President Bill Clinton and his dog with Reno's face superimposed on the dog's head. Nothing in Florida law prevents such third-party groups from making expenditures on a candidate's behalf, as long as they register as political action committees and disclose contributions and expenses. Bush's campaign sent a copy of the Barrero letter to the Reno campaign. Janet Reno will not engage in personal attacks and she will not support organizations that engage in personal, spiteful attacks, said Nicole Harberger, a Reno campaign spokeswoman. Will there be a healthy debate on the issues? Yes. Before we dive right into this, I would like to also bring your attention to what the law librarian at Ferris State University has to say about the common law trade name. http://www.ferris.edu/library/patent/common.html Patent and Trademark Depository Library. Common law benefits include: rights accrue from use of the mark in connection with the goods/services. No paperwork or fees. Common law drawbacks include: the mark lives and dies with the trademark owner/user. Protection is limited to a geographical area of use. Little notice is provided to third parties. The user must prove priority over others. Generally, the marks can only be enforced in state courts. Compiled by Ray Dickinson, librarian. Last update, January 28, 2002. Now a piece from BitLaw. The term common law indicates that the trademark rights that are developed through use are not governed by statute. Instead, common law trademark rights have been developed under a judicially created scheme of rights governed by state law. Federal registration, a system created by federal statute, is not required to establish common law rights in a mark, nor is it required to begin use of a mark. However, federal registration, if available, is almost always recommended, and gives a trademark owner substantial additional rights not available under common law. See the BitLaw discussion of federal registration for more information. Common law trademark rights are limited to the geographic area in which the mark is used. Thus, if a coffee blend is sold under the name Blaster in California only, the trademark rights to that name exist only in California. If another coffee retailer begins to market a different blend in New York under the same name, assuming they had no knowledge of the California company, then there would be no trademark infringement. However, if the New York company attempted to sell their coffee blend nationwide, they would discover that the California company's common law rights to the mark would prevent them from entering the California market. Since no registration is required in order to establish common law rights to a trademark, it can be difficult to discover whether anyone has trademark rights in a particular mark. This is the legal background for the difficulties and expenses involved in trademark clearance searches. If registration were required for trademark rights, clearance searches would only need to examine trademark registers. Under U.S. law, however, an attempt must be made to discover these common law rights. The common law trademark/copyright. Introduction. The power of the trademark/copyright notice is the common law, unwritten, ancient, and immutable. The trademark/copyright notice forms the basis of your ability to enforce ownership rights over all property associated with, and registered in the trade name of, your juristic person. For this reason it is vital that you formally establish your claim of right of ownership of property under the common law on the public record. Ideally you would file your trademark agreement and notice at the county clerk/recorder's office, but this office, like all government offices, has been set up not for the purpose of enhancing the quality of life for the little guy, but for functioning as an integral cog in Big Brother's property and wealth confiscation machinery. The common law is alive and well and underlies all intercourse amongst all Americans, and all law forms as well, including the Uniform Commercial Code, but the criminal brilliance of the chosen masters in the legal, commercial, and financial arenas has completely obliterated people's awareness of it. The Norman French attorneys that destroyed the quality of life and property rights in England beginning in 1066 have carried forward across the centuries and have accomplished the same feat on this side of the Atlantic. By switching the language, having you believe a word means one thing in common usage but something totally different in law, grab a Black's Law dictionary and look up the word rectum. No joke, please look it up. It means an accusation or trial. The whole of English society was thrown into upheaval and the king's esquires, with force of arms backing them, legally ravaged the population. The same tribe of miscreants is now wreaking its wrath on America and the rest of the world. The new attorney language is Latin, not French, and people are drowning in an endless ocean of code. Most people are too overwhelmed by the rigors of staying alive and paying their bills and taxes to even mount a defense to even know what, exactly, is wrong. No matter the amount of grief, misery, and chaos inflicted by the man-haters of the money power, however, accessing the common law instantly levels the entire playing field. All names constitute property, nothing more, nothing less. The esquire shysters that enforce the agenda of the legal masters of the world have gotten one and all to identify with the name, have gotten people to believe that they are their own name. A name is useful communication tool for getting someone's attention, but response is voluntary, and this is what sovereignty is all about. When Big Brother's operatives ask you for your name, they are asking you to turn over your private property. They are asking for you to voluntarily surrender control of your private property so they can use the name you give them to create an account and lodge a charge in it, the private property that you voluntarily give them. If they do not get a name, guess what? There is no account and there is no charge. On the other side of the coin, when someone takes your property without authorization, i.e. without you voluntarily giving it to them, and uses it for financial gain, you have an innate right, the nature of common law, to charge them for it. The UCC is expressly designed by esquire frontmen to facilitate this undertaking. You just weren't supposed to find out about it. All you need is the perpetrator's name and address, and the UCC to enforce your common law property rights. The common law trademark/copyright of the name has been constructed so as to align perfectly with the agreed upon tenets of the UCC, thereby augmenting your common law right to require and obtain just compensation for the unauthorized use of your private property. The thoroughness of the trademark/copyright notice in spelling out the minute details of the terms of doing business with you demonstrates the good faith and reasonableness and full disclosure on your part, because the intention is to follow through exactly as stated in the trademark/copyright notice and do what you say will do if someone chooses to do business with you. You must understand the trademark is governed by your state trademark laws. Here is some information regarding state trademarks and rules, violations, as well as procedures. Alaska. Trade and Commerce Title 45, Chapter 45.50, Competitive Practices and Regulation of Competition, Article 01, Trademark. Alabama. Title 8 Commercial Law and Consumer Protection, Chapter 12, Trademarks, Names, Marks, Devices, and Labels. Arkansas. Chapter 71 of the Arkansas Code, Trademarks and Labels. Arizona. Title 44, Trade and Commerce, Chapter 10, Competition and Competitive Practices, Article 3 Registration and Protection of Trademarks and Service Marks, 44 to 1441, Definitions 44 to 1442, Registrability 44 to 1443, Application for Registration 44 to 1444, Certificate of Registration, Admissibility as Evidence 44 to 1445, Duration of Registration, Renewal Notice, Application and Fee 44 to 1446, Assignment of Mark and Registration 44 to 1447, Records 441,448. Cancellation of Registrations 44 to 1448.01, Injury to Business Reputation, Dilution 44 to 1449, Classification of Goods or Services 44 to 1450, Fraudulent Registration, Damages 44 to 1451, Remedies for Infringement 44 to 1452, Common Law Rights 44 to 1453, Counterfeit Marks, Violation, Classification, Presumption, Seizure, Forfeiture, Remedies, Definitions 44 to 1455, Use of unauthorized copy of computer software, Violation, Classification 44 to 1456, Use of trademark container for other articles, Violation, Classification. California. Division 6, Business Rights General Provisions, Chapter 2, Registration and Protection of Trademarks, Section 14200 ETSEQ Colorado. Title 7 Corporations and Associations, Chapter 7, Trademarks, Business and Farm Names, Article 70, Trademarks, 7-70-101 to 7-70-113. Definitions, Section 7-70-101, Application for Registration, 7-70-102, Certificate of Registration, 7-70-103, Duration and Renewal, 7-70-104, Assignment and Change of Name, 770. 105, Records, 7-70-106, Cancellation by Secretary of State, 7-70-107, Action for Cancellation, 7-70-108, Classification, 7-70-109, Fraudulent Registration, 7-70-110, Infringement Civil Action 7-70-111, Remedies, 7-70-112, Common Law Rights, 7-71-113, Membership of Firm Business under Assumed Name Fees, 7-71-101, Penalty for Failure to File, 7-71-102. Connecticut. Title 35, Trade Regulations, Trademarks and Collective and Certification Marks, Chapter 621A, Trademarks and Service Marks, see also Chapter 620A Marks. Delaware. Title 6, Chapter 33, Trademarks, Brands and Labels. 3301 Short Title 3302. Definitions. 3303 Registrability 3304. Application for Registration. 3305 Certificate of Registration. 3306 Duration and Renewal. 3307 Assignment. 3308 Records. 3309 Cancellation. 3310 Classification. 3311 Fraudulent Registration. 3,312 infringement. 3,313 injury to business reputation, dilution. 3,314 remedies, including injunctions against forged or counterfeited trademarks, service marks, or copyrighted or registered designs. 3,315 common law rights. Florida. Title XXXIII Regulation of Trade, Commerce, Investments, and Solicitations, Chapter 495, Registration of Trademarks and Service Marks Definitions. 495.011 Registerability. 495.021 Reservation. 495.027 Application for registration. 495.031 Use by related companies. 495.041 Disclaimers. 495.051 Certificate of Registration. 495.061 Duration and Renewal. 495.071 Assignment. 495.081 Records. 495.091 Cancellation. 495.101 Classification. 495.111 Fraudulent Registration. 495.121 Infringement. 495.131 Remedies. 495.141 Injury to business reputation, dilution. 495.151 Common law rights. 495.161 Effective date, repeal of prior acts. 495.171 Construction of Chapter 495.181. Georgia. The Official Code of Georgia governing trademarks, Title 10, Section 1 to 440 et sec. Hawaii. Division 1, Title 20, Chapter 482, Trademarks, Prints, Labels and Trade Names, Registration and Protection of Section 482 to 1 Definitions 482 to 2 Certificate 482 to 3 Record, Issuance and Effect of Certificate 4823.5. Penalty 482 to 4 Certain prints, labels, trademarks, service mark, union labels and trade names not to be adopted or used 482 to 5 Penalty 482 to 6 Revocation of certificate, non-use 482 to 7 Application of law, reissue on non-user 482 to 8 Revocation of certificate, ownership 482 to 9 Appeal 482 to 10 Registration of name, title, or other mark or device on bottles, siphons, tins, kegs, or other containers 482 to 11 Unlawful traffic in bottles, etc., registered under Section 482 to 10 482 to 12 Unlawful use of milk bottles, etc., penalty. Iowa. Registration and Protection of Marks, of Title 13, Subtitle 5. 548.101 Definitions, 548.102 Registerability 548.103 Application for registration. 548.104 Filing of applications. 548.105 Certificate of Registration. 548.106 Duration and Renewal. 548.107 Assignments, Changes of Name, and Other Instruments. 548.108 Records. 548.109 Cancellation. 548.110 Classification. 548.111 Fraudulent Registration. 548.112 Infringement. 548.113 Injury to business reputation dilution. 548.114 Remedies. 548.115 Forum for actions regarding registration service on out-of-state registrants. 548.116 Common law rights. 548.117 Fees. Idaho. Title 48, Monopolies and Trade Practices, Chapter 5, Registration and Protection of Trademarks, 48 to 501 Definitions 48 to 502 Registerability 48 to 503 Application for registration 48 to 504 Filing of applications 48 to 505 Certificate of Registration 48 to 506 Duration and Renewal 48 to 507 Assignments, Amendments, changes of name and other instruments 48 to 508, records 48 to 509, cancellation 48 to 510, classification 48 to 511, fraudulent registration 48 to 512, infringement 48 to 513, injury to business reputation dilution 48 to 514. Remedies 48 to 515, forum for actions regarding registration service on out-of-state registrants 48 to 516, common law rights 48 to 517, fees 48,518. Time of taking effect, repeal of prior acts, intent of act. Illinois compiled statutes, Chapter 765, Property, Trademark Registration and Protection Act 1036. See also rights. This has been a production by the Mental Chemist for Study and Education. Property, miscellaneous property. Copyright 2024 Act 1040. Indiana Code, Title 24, R2 Trademarks, Trade Names and Trade Secrets. Kansas Statutes, Chapter 81 Trademarks and Service Marks, Article 2, 81 to 201. Title. Kentucky Revised Statute, Title 29, Chapter 365 561 Legislative Intent. 563 Definitions for KRS 365.561 to 365.613. 567 Registerability. 571 Application for registration. 573 Filing of applications. 577 Certificate of registration. 581 Duration and renewal. 583 Assignments, change of name, and other instruments. 587 Records. 591 Cancellation. 593 Classification. 597 Fraudulent registration. 601 Infringement. 603 Remedies. 607 Forum for actions regarding registration service on out-of-state registrants. 611 Common law rights. 613 Fees not refundable. Louisiana Revised Statutes, Section 213, Powers of the Secretary of State, Reservation of Trade Names, Trademarks, and Service Marks. Maine. Title 10, Commerce and Trade, Part 4, Trademarks and Names, Chapter 301A, The Registration and Protection of Marks. 1521. Definitions. 1521A Use of marks. 1522. Registration. 1523. Attested copy. 1524. Duration and renewal. 1525. Assignment. 1525A Amendment. 1526. Records. 1526A Information Requests. 1527. Cancellation, Classification. 1527A Powers of the Secretary of State. 1527B Expedited Service. 1527C Access to Secretary of State's Database. 1527D Publications. 1528. Fraudulent Registration. 1529. Infringement. 1530. Injury to Business Reputation, Dilution. 1531. Remedies. 1532. Common law rights. Maryland. Business Regulation, Index to Trademark Laws of Maryland, Article 1 to 401 ETSEQ, 1 to 401. Definitions. 1 to 402. Effect of Subtitle. 1 to 403. Records. 1 to 404. Registration authorized. 1 to 405. Classes of goods and services. 1 to 406. Applications for registration. 1 to 407. Hearings. 1 to 409. Issuance and contents of certificate of registration. 1 to 410. Term and renewal of registration. 1 to 411. Assignment. 1 to 412. Cancellation of registration. 1-413. Fraudulent registration. 1 to 414. Infringement. Massachusetts. General Laws of Massachusetts, Chapter 110B, Registration and Protection of Trademarks. Section 1. Definitions. Section 2. Application for registration of trademark, filing. Section 3. Registration restrictions. Section 4. Certificate of registration, issuance, status as constructive notice and as evidence, defenses. Section 5. Effective term, renewal, fee, notification of expiration, Statement of use. Section 6. Assignment of marks and registration, recording, fee, good faith purchasers for value protected. Section 7. Public records. Section 8. Cancellation of registration. Section 9. Rules and regulations, classes of goods and services. Section 10. Fraudulent procuring of registration, damages. Section 11. Use or counterfeiting of marks without consent of registrant, remedies. Section 12. Injunctive relief. Section 13. Counterfeit or imitation marks, injunction, damages, destruction. Section 14. Common law rights. Section 15. Rules and regulations, administrative proceedings. Section 16. Severability. Michigan. Act 242 of 1969, Trademarks and Service Marks. Minnesota. Chapter 333, Assumed Names, Insignia and Marks. 333.001 Definitions. 333.01 Commercial Assumed Names. 333.02 Filing of Certificate. 333.03 Repealed, 1978 C698 S9 333.035 Amendment of Certificate. 333.04 Secretary of State, Duties, Fees. 333.05 Repealed, 1978 C698 S9 333.055 Term of Certificate, Renewal, Notices, Fees. 333.06 Pleading failure to file certificate, costs. 333.065 Penalty for violation. 333.07 Lodges, societies and the like may register. 333.08 Application. 333.09 Secretary of State to keep record and index. 333.10 Duplicates not registered. 333.11 Issuance of certificates. 333.12 Fees. 333.13 Violations, penalties. 333.135 Improper use of insignia. 333.14 Unauthorized use is a crime. 333.15 Threatened use may be restrained. 333.16 Vested rights not affected. 333.17 Forbidden in business, marine exception. 333.18 Definitions. 333.19 Unregisterable matter, collective and certification marks. 333.20 Application, form, signature, specimen of mark, fee. 333.21 Certificate of registration, issuance, evidentiary effect. 333.22 Term of registration, renewal, notice, fee. 333.23 Conveyances of marks, recordation, fee, necessity. 333.24 Secretary of State's record of marks. 333.25 Cancellation of marks. 333.26 Must use U.S. Patent and Trademark Office system. 333.27 Improper registration, liability. 333.28 Identical or similar marks, liability for misuse. 333.285 Dilution of distinctive famous mark may be enjoined. 333.29 Remedies. 333.30 Marks acquired at common law. 333.305 Forum is District Court, Service on non-resident registrant. 333.31 Service of process upon non-resident registrants. 333.40 Trademark, when deemed affixed. 333.41 Trademarks of workers' unions. 333.42 Counterfeiting or dealing in counterfeits, how punished. 333.43 Registration. 333.44 Fraudulent registration or use, penalty. 333.45 Illegal use of certificate of registration. 333.50 Unauthorized use is a crime. 333.51 Threatened use may be restrained. 333.52 Vested rights not affected. 333.53 Unauthorized use is a crime. 333.54 Threatened use may be restrained. Mississippi. Mississippi Code of 1972 as amended, Title 75 Regulation of Trade, Commerce, and Investments, Chapter 025. 75-25-1 Definitions. 75-25-3 Registerability. 75-25-5 Application for registration. 75-25-7 Certificate of registration. 75-25-9 Duration and renewal. 75-25-11 Assignment. 75-25-13 Records. 75-25-15 Cancellation. 75-25-17 Classification. 75-25-19 Fraudulent registrations. 75-25-21 Infringement. 75-25-23 Remedies. 75-25-25 Common law rights. 75-25-27 Fraternal associations or societies. 75-25-29 Effective January 1, 1997 Actions for cancellation. 75-2531 Effective January 1, 1997 Good faith acquisition of marks. 75-2533 Effective January 1, 1997 Fees. Missouri. Missouri Revised Statutes, Chapter 417, Trademarks, Names and Private Emblems, Section 417-005 Definitions. Section 417-011 Prohibited Marks, Section 417.016 Registration of Trademark Application, Contents Information required by Secretary of State Fee, How payable refusal. To register mark, procedure. Section 417-018 Additional fee. Section 417-021 Certificate of registration, how issued admissible as evidence duplicate of certificate, application, fee abstract. Of mark, fee. Section 417-026 Term of registration notice of expiration, when required. Section 417-031 Assignment of mark, procedure. Section 417-036 Registry of marks open to public. Section 417-041 Cancellation of marks, when. Section 417-046 Classes of goods and services Single application for mark to cover only one class. Section 417-051 Fraudulent filing or registration Civil damages to injured party. Section 417-056 Prohibited acts Civil action for damages, when. Section 417-061 Injunctive relief, when order for payment to owner of mark destruction. Of counterfeit marks. Section 417-066 Common law marks not affected pending suits not affected actions to require cancellation of a mark or to compel registration, venue, parties. Montana. Title 30, Chapter 13, Assumed business names, trademarks, and related rights, Part 3 Trademarks. Nebraska. Trademark Registration Act of 2000, Sections 87 to 100 and 26 through 87 to 144. Nevada. Nevada Revised Statutes, Registration and Protection of Trademarks, Trade Names and Service Marks Section 600.240 to 600.450. New Hampshire. Revised Statutes of the State of New Hampshire, Chapter 350A, Model State Trademark Act. New Jersey. Title 56, Trade Name, Trademarks and Unfair Trade Practices, Chapter 3, 1995 A Mandatory and Supplementary Act. New Mexico. Chapter 57, Article 3B, Trademarks 57-3B1. Short Title 57-3B2. Purpose and Intent of Act 57-3B3. Definitions 57-3B4. Registerability 57-3B5. Application of registration 57-3B6. Filing of application 57-3B7. Certificate of registration 57-3B8. Duration and renewal 57-3B9. Assignments, changes of name and other instruments. 57-3B10. Records. 57-3B11. Cancellation. 57-3B12. Classification. 57-3B13. Fraudulent registration. 57-3B14. Infringement. 57-3B15. Injury to business reputation, dilution. 57-3B16 Remedies. 57-3B17. Applicability. New York. GBS, General Business Article 24 Trademarks, Service Marks and Business Reputation. North Carolina. Chapter 80. Trademarks, Brands, etc. Article 1, Trademark Registration Act. North Dakota. North Dakota Secretary of State Office with links to Century Code, Chapter 47 to 22 and forms in .pdf format. Ohio. Ohio Revised Code, Chapter 1329, Labels and Marks. Oklahoma. Oklahoma Trademark Code, Title 78, Chapters 21 to 29. Oregon. Oregon Revised Statutes, Chapter 647, Trademarks and Service Marks. Pennsylvania. Trademark Registration Fees and Forms. Rhode Island. Chapter 6-2 Registration and Protection of Trademarks Index of Section 6-2-1 Definitions. 6-2-2 Application for Registration. 6-2-3 Registrability. 6-2-4 Certificate of Registration. 6-2-5 Duration and Renewal. 6-2-6 Assignment. 6-2-7 Records. 6-2-8 Cancellation. 6-2-9 Classification. June 2, 10 Fraudulent registration. June 2, 11 Infringement. June 2, 12 Injury to business reputation dilution. June 2, 13 Remedies. June 2, 14 Common law rights. June 2, 15 Severability. June 2, 16 Termination of prior registrations. South Carolina. Title 39, Trade and Commerce, Chapter 15, Labels and Trademarks. South Dakota. Title 37, Trade Regulations, Chapter 37-6, Trademark and Service Mark Protection. Tennessee. Title 47, Chapter 25 Trade Practices, Part 5, Tennessee Trademark Act of 2000. Texas. Business and Commerce Code, Chapter 16, Trademarks. Utah. Utah Code Title 70 Chapter 03 Trademarks and Service Marks. Vermont. Title 09, Commerce and Trade Chapter 071, Trademarks, Registration of Name or Mark. Virginia. Title 59.1, Trade and Commerce, Chapter 6.1, Registration and Protection of Trademarks and Service Marks 59.1 to 92.1. Short Title. 59.1 to 92.2. Definitions. 59.1 to 92.3. Registrability 59.1 to 92.4. Application for registration. 59.1 to 92.5. Filing of applications. 59.1 to 92.6. Certificate of registration. 59.1 to 92.7. Duration and renewal. 59.1 to 92.8. Assignments and changes of name. 59.1 to 92.9. Records. 59.1 to 92.10. Cancellation. 59.1 to 92.11. Classification. 59.1 to 92.12. Infringement. 59.1 to 92.13. Remedies. 59.1 to 92.14. Service on out-of-state registrants. 59.192.15. Common law rights. 59.1 to 92.16. Fees 59.1 to 92.17. Commission may consider final judgments. 59.1 to 92.18. Appeals from final action of Commission. 59.1 to 92.19. Regulations and forms. 59.1 to 92.20. Fees to cover expense of regulation. 59.1 to 92.21. Olympic symbols. Washington. Revised Code of Washington, Trademark Registration, Chapter 19.77. West Virginia. Chapter 47, Regulation of Trade, Article 2, Trademarks in General. Wisconsin. 2001 Wisconsin Statutes, Chapter 132, Trademarks, Badges and Labeled Products. Wyoming. 2000 Wyoming Statutes, Title 40, Trade and Commerce, Chapter 1, Trademarks and Service. Marks. http://media.wiley.com/product_data/excerpt/14/04712094/0471209414.pdf. Trademark Basics Overview. After reading this chapter you will be able to understand why the legal system protects trademarks. Identify trademarks. Understand the scope of state and federal trademark laws. Know how to use trademarks in commerce. Compare trademarks to utility patents, design patents, and copyrights. Trademarks have been used for centuries, probably as long as there has been more than one person carrying out a particular trade, or selling merchandise of a particular type, at the same market, or in the same town. An important part of business is developing a reputation for selling unusual merchandise, or for quality or variety of products, or for high value. A business can succeed only if customers buy its products or use its services. One of the most important functions of marketing and advertising is to create demand, not just for a particular type of product, but for the advertiser's or marketer's own goods. Trademarks, words, pictures, combinations of words and images, even sounds or fragrances, are important tools in identifying the business that provides the goods or services. A good trademark makes the product stand out. Because trademarks are such a key part of doing business, federal and state law protect a business's right to identify its own merchandise and to keep other people from counterfeiting merchandise or using confusingly similar trademarks. However, the legal rules for trademarks, and the related concept of trade dress, the appearance and packaging of merchandise, are complicated and sometimes counterintuitive. They are not necessarily what a person in business would assume, based on experience in selling products. This book is designed to make confusing rules easier to understand. Focus of the book. This book covers a spectrum of related topics. Following the introduction of trademarks and trademark law in chapters 1 and 2, the main concentration is on trademarks themselves. In addition, chapter 2 touches on a large and growing group of issues, the difficult relationship between trademarks and the internet, including but not limited to when trademarks can be used as URLs and when a cybersquatter can be punished for misuse of domain name registration. In many ways, the concepts of brand and trademark are closely related, although brand is a more modern and trademark a more traditional idea. But even though they are similar, they are not identical. Both of them involve product image and goodwill, but the concept of trademark focuses on the source of the goods. A consumer might have very high awareness of brand, might, for instance, have a shopping list that contains Jif peanut butter, Arid extra dry deodorant, Del Monte canned vegetables, Camel's canned soups, Crest toothpaste, and so on. This consumer might have a strong preference for these brands, based on a belief in their superior quality and attractiveness, and might take a rain check rather than purchase a competing brand, yet have no knowledge or interest in who manufactured the preferred brands. In fact, in today's business climate, where mergers and product divestitures are common, a brand might have been owned by several companies. Thus, the brand does not provide proof of source. In this book, we focus on the concepts of trademark. Chapter 3 covers how to search to see if a desired trademark is available, and how to register a trademark. Chapter 4 discusses what to do in case of an allegation of trademark infringement or if the trademark owner believes that the trademark has been infringed. The subjects of service marks and trade dress are addressed in Chapter 5. Chapter 6 covers threats to trademarks. However, a trademark is only one form of intellectual property. In the current business climate, businesses are becoming more and more aware of the importance of trademarks, trade secrets, patents and design patents, copyrights, and digital media assets to business success. The rules affecting these forms of intellectual property can be complex and overlapping. Inventing, manufacturing, and marketing a product can involve multiple forms of intellectual property, each with its own legal consequences. These issues are addressed in Chapter 7. In addition to trademarks and related subjects, this book also covers the law of unfair competition in business, because other forms of unfair business practice can overlap with trademark infringement. Chapter 8 tackles this subject. For your convenience, the book closes with several appendices and legal forms. When used in conjunction with the information presented in this text, the end material should equip you with the essential concepts you need in handling trademark issues. Sources of trademark law. Trademark law was already in existence in England when the American Revolution occurred, and many of those concepts were adopted as U.S. law evolved. Merely using a trademark in commerce creates some protectable rights against unfair competition and imitation of the trademark. This is known as a common law trademark. The rights that arise are limited to the geographic area in which the mark is being used. However, as described in detail in this book, registering a trademark with the state, the Federal Patent and Trademark Office, or both, is often worthwhile because it increases the rights of the registrant against a trademark infringer. Remedies for trademark infringement can include injunctions, seizure of infringing or counterfeit merchandise, and money damages. See Chapter 4. Once a trademark is registered, it will become part of a large standard database that is open to the public. The practical effect is that businesses that are contemplating the use of a new trademark can search the database and discover if it is already in use, or if it might be considered confusingly similar to a trademark already in existence. The legal effect is that once a trademark is registered, or even published for objections, everyone is deemed to have knowledge of it, and can be held responsible for the knowledge. Research sources. There are registers listing state and federally registered trademarks, but no counterparts for common law trademarks. Nevertheless, there is a legal obligation to at least try to research common law trademarks as part of the trademark search, for instance, by consulting telephone listings and business directories and examining the trademarks used on products available in stores. Once a trademark is registered with the Federal Patent and Trademark Office, PTO, the symbol registered can be used in connection with the trademark. Any registered trademark, on either the principal or the supplemental register, can use the symbol. Any trademark, registered or not, can be identified with the symbol trademark. This symbol just indicates that trademark rights have been asserted in the mark, not that any government agency has approved or registered the mark. Another advantage of registering a trademark is that, 5 years after a trademark has been registered, the general rule is that it will become incontestable, that is, no one will be allowed to bring a legal challenge to the validity of the trademark. However, the law contains a list of exceptions. A trademark can be challenged even after 5 years if it was obtained fraudulently, if the trademark owner has abandoned it, has stopped using it in commerce, and if the trademark has become generic, that is, if it is used to identify a whole class of products rather than the products of a specific company. State trademark law. All of the states have some trademark and unfair competition laws of their own. In other words, even though patent law is considered so purely federal that states are not allowed to operate in this area, trademark law is shared by both the state and federal systems. State trademark laws tend to come into play when a trademark is used purely locally, not nationwide or in a multi-state area, or if a trademark is of a type that is not eligible for listing on the federal principal register. In general, state trademark law doesn't create a presumption that the trademark is valid, and doesn't make trademarks incontestable after a 5-year period, the way federal law does. Model State Trademark Bill. 46 states have adopted the Model State Trademark Bill, MSTB, which specifies how trademarks and service marks can be registered. Under the MSTB, radio and TV program titles and character names can be registered as service marks. The MSTB provides that a mark is in use when it is used in ordinary business. Token transactions to reserve a mark don't count. Like federal law, the MSTB calls for marks to be placed on the goods, their containers, their displays, or tags or labels attached to the goods. The mark is supposed to be used on sales documentation for bulk goods or other items to which marks cannot be affixed. Service marks are to be displayed in sale or advertising or services. The MSTB, like the Lanham Act, discussed later, denies registration to marks that are immoral, deceptive, scandalous, or disparaging to individuals, that are just descriptive or misdescriptive, geographically or otherwise, or that are primarily merely a last name unless the last name has become distinctive through use in commerce. To preserve the right of publicity, the MSTB does not permit registration of a mark that consists of or includes a living person's name, signature, or portrait, unless the person has given consent. The term of protection under the MSTB is 5 years from the date of registration. It can be renewed an indefinite number of times, 4-5. Evidence. Under the MSTB, using a last name as a trademark for a 5-year period before the attempt to register it counts as evidence that it has become distinctive 5 years at a time, by filing a renewal request within 6 months before the expiration of the term. If a second trademark is used that is confusingly similar to an existing trademark, the holder of the first trademark is entitled to get an injunction on the basis of unfair competition that will require the second trademark to be taken out of use. The confusingly similar trademark is subject to cancellation, and holders of the original trademark can get damages for trademark infringement and dilution. Dilution is imitating a trademark in a way that makes it less valuable by making potential customers associate inferior merchandise with the trademark. Under the MSTB, trademarks are considered abandoned either when there has been a 2-year period without use of the trademark or the registrant of the mark stops using it and intends never using it again. Abandonment also occurs when the mark becomes generic or otherwise is no longer used as a trademark. Trademarks can be cancelled for the following reasons. The trademark holder voluntarily requests its cancellation. A court holds that the mark has been abandoned. A court holds that the registrant doesn't really own the mark. There was fraud or other impropriety in the securing of the registration. The mark is confusingly similar to another mark. The mark has become generic. Federal trademark laws. However, the most significant laws governing trademarks, and most other forms of intellectual property, are federal. The central statute covering trademarks is a federal law called the Lanham Act. The Lanham Act is a federal law, passed, and occasionally amended, by Congress. The federal agency responsible for administering federal trademark law is the Patent and Trademark Office, PTO. The PTO's regulations can be found in the Code of Federal Regulations, CFR. Amendments to the Lanham Act include the Trademark Revision Act of 1988 and more recent laws banning cybersquatting, improper practices involving registration of Internet domain names, and counterfeiting of trademarked merchandise, for example, imitations of Louis Vuitton handbags. The Lanham Act protects trademarks, as well as related types of marks such as service, collective, and certification marks, that are used in commerce. At first, the Lanham Act protected only trademarks that had already been put into use. However, under current law, a trademark can be registered and protected on the basis of intent to use it in the future. For instance, it can be used in connection with a product that is under development and will be released in the future. This is known as an intent to use, ITU, application. The final registration will not be granted until the intention to use matures and turns into actual use. The applicant has to update the application by submitting a verified statement and specimens proving that the mark has been placed in actual use in interstate or foreign commerce. Depending on the time when it is filed, the appropriate form is either an amendment to allege use, AAU, or a statement of use, SU. Lanham Act 32. 1. A person who has registered a trademark has the right to bring a civil suit against anyone who does one of two things without the consent of the registrant. 1. The infringer uses in commerce any reproduction, counterfeit, copy or colorable imitation of a registered mark in business, if such use is likely to cause confusion, or to cause mistake, or to deceive. The provision about colorable imitations is there to make sure that infringers can't make tiny changes in the mark and then use that as a defense against a 32(1) lawsuit. 2. The infringer reproduces, counterfeits, copies, or colorably imitates a registered mark, and then applies the non-legitimate mark to labels, signs, prints, packages, wrappers, receptacles or advertisements used in trade, once again if the likely result is confusion, mistake, or deception. The difference between these two very similar sounding provisions is that the trademark holder can only get an award of damages or lost profits in a case of the second type if the infringer committed its acts with knowledge that the imitation is intended to be confusing or deceptive. It is not necessary to prove that the infringer's intentions were wrongful to win a case of the first type. Lanham Act 43, A. The Lanham Act also forbids a very broad range of unfair or inappropriate conduct that could cause consumer confusion even if there are no registered trademarks involved. Section 43(a), which is often used in trade dress and false advertising cases, allows a civil suit to be brought by any person who believes that he or she is or is likely to be damaged by such act. The forbidden acts are use of words, symbols, devices, etc., including combinations. False designation of origin. False or misleading description of fact. False or misleading representation of fact, either on or in connection with any goods or services or any container, if the wrongful act occurs in commerce. Section 43(a) bans all activities that are likely to cause confusion or mistake as to the affiliation, connection, or association of such person with another person, or as to the origin, sponsorship, or approval of his or her goods, services, or commercial activities by another person. This is broad enough to cover, for example, an advertisement that describes rhinestone jewelry as diamond jewelry. It also covers trademark and trade dress infringement, because that misleads or could mislead consumers about who has produced the merchandise in question. Use in commerce for legal purposes, trademarks do not exist in the abstract. They identify the goods or services of a particular provider and are related to the goodwill associated with the product. Therefore, federal trademark law does not allow a trademark to be registered until it is already in use, or unless the party that seeks to register the trademark is willing to go on record that it intends to use the trademark in commerce in the future. Once the registrant stops using the trademark in commerce, it is abandoned. A defendant accused of trademark infringement can get the case dismissed by showing that the owner abandoned the trademark that allegedly was infringed. Furthermore, even if a trademark has been registered and in use for 5 years, which would otherwise probably make it incontestable, someone else who wants to use the same or a very similar trademark. Abandonment. Under earlier law, failing to use a trademark for 2 years constituted strong evidence that the trademark had been abandoned. However, effective January 1, 1996, the Lanham Act has been amended. Now, abandonment is not presumed until 3 years have passed without use of the trademark can advance the legal argument that the trademark has been abandoned by its original owner. Under 45 of the Lanham Act, use in commerce means bona fide use in the ordinary course of trade. Token usages that are merely intended to preserve the mark are not sufficient, because unless the trademark is used in connection with marketing and at least attempted sale of goods, there's no goodwill to protect. A service mark is used when 2 conditions are met: the mark appears in ads and promotional materials, and the service is actually being provided to the public. Furthermore, 45 refers to trademarks being used on the goods. Therefore, as long as the trademark can physically be attached to the goods, it should be placed there and not just on the documents associated with the goods or in advertisements. Of course, some merchandise simply can't have trademarks attached, things sold in bulk like fuel oil, for instance, so in that case the trademark must be used on displays associated with the merchandise, or on the sales documents. Some uses get a more favorable eye. Some literal-minded PTO examiners will reject applications for a mark that will only be used as a design on the front of a t-shirt, example a t-shirt using the photograph and logo of a band, a Harley-Davidson or Budweiser t-shirt. Their argument is that this is purely ornamental, and therefore doesn't use the trademark to indicate the source of the shirt. To avoid this problem, the trademark can be used on the shirt's label and the garment tag attached to the shirt. Examiners have less trouble with smaller logos, for example, the Polo Horseman embroidered on a shirt. The risk of confusion. One of the most basic trademark concepts is the risk of confusion. The PTO examining attorney will refuse to register a trademark if it is close enough to an existing trademark to create such a risk. The potential for confusion is a key issue in infringement suits. Legal analysts identify several kinds of confusion that can be harmful to competition. Therefore, trademark law tries to eliminate these types of confusion. Source confusion. The source of the goods is the business that controls the production, including quality, of the goods, that is, consumers think a company A product is actually made by company B. Confusion about sponsorship, approval, or certification. For example, potential buyers think that mint cookies from a non-approved bakery are Girl Scout cookies, or are induced to believe that a fabric bears the wool mark when this is not the case. Reverse confusion. The public thinks that a newcomer to the market makes goods that actually come from an established source. Subliminal or associational confusion. Consumers think that they have seen the trademark, or something like it, somewhere before. This weakens consumers' association between the goods and the actual holder of the trademark. Although usually the test is consumer confusion, other parties' confusion may also be relevant. People who influence purchasing decisions, or distributors and wholesalers, lenders and investors, employees, and people who receive the goods as gifts or buy them second-hand. According to the Restatement, 3rd, of Unfair Competition, a restatement is a volume of legal trends in a particular subject, compiled by lawyers who are experts in that subject. Likelihood of confusion is hard to prove, because it is unlike most other questions of evidence. Those other questions involve past events, but likelihood of confusion involves a future state of mind. It may be necessary to draw conclusions by projecting existing consumer attitudes and behavior, in the relevant market, into the future. For trademarks that are word marks, or include both words and designs and therefore can be pronounced, confusion might be found on the basis of similarity of pronunciation, even if the marks are spelled differently. This is especially true if the merchandise is sold by telephone or advertised on radio or television. It is less likely to become an issue if the product is sold in stores where customers see it on the shelf. Common prefixes and suffixes used in a particular industry, such as ultra or col or ison for medicine, are likely to be disregarded in deciding whether confusion is likely. Many court decisions consider nearly all items of clothing to be closely related, so they are considered together in terms of likelihood of confusion. For example, a defendant would not have a very strong argument that the plaintiff's trademark was used on sweaters and the defendant's was used on blouses. In fact, because some items of clothing are unisex, and manufacturers often make both men's and women's clothing, clothing for both is often treated as a single market. The legal system assumes that trademark owners have an interest in expanding their product lines. So another issue is whether the trademark owner would be likely to bridge the gap by manufacturing the product that the defendant claims is in a completely separate market where consumers would not be confused. The basic legal rule is that using trademarks in comparisons is acceptable. Thrifty Gal Moisture Cream has the same percentage of vitamin C and alpha-retinol as luxury Posh moisturizer, but ours costs $10 an ounce and theirs is $100 an ounce. The theory is that comparison ads make it clear that two different brands are involved, so there is no risk of confusion, and the public is entitled to accurate information about different brands. If the information is inaccurate, it becomes a false advertising or unfair competition question. Trademarks and other forms of intellectual property. Trademark law is part of the law of intellectual property. It is important to understand how trademark law interacts with other intellectual property topics, especially because the same product and certainly the same marketing campaign may include several different forms of intellectual property protection. Patents exist to protect functional features of manufactured items, utility patents, and the way manufactured items look, design patents. Copyrights protect the way that ideas are expressed in written, musical, dramatic, and visual works, although not the ideas themselves. Trademarks protect the words, designs, and other indicators of the source, origin, and sponsorship of merchandise. Patents. A utility patent is what most people think of when they hear the word patent. A utility patent protects the functional features of an item, a composition of matter, or a novel method or process, for a period of 20 years, for patents issued on the basis of applications filed after June 8, 1995, or 17 years from the date of issue or 20 years after the filing date, whichever is longer, for filings before June 8, 1995. Of course, many of those patents remain in effect. A utility patent can only be granted to a useful, novel, non-obvious invention that makes a meaningful step forward from the prior art, the state of technology existing before the new invention was created. A design patent, on the other hand, protects the aesthetic appearance of an object. For instance, a utility patent might cover a new way for vacuum cleaners to collect dust and dirt, whereas the distinctive shape and appearance of the vacuum cleaner might be entitled to a design patent. A design patent can be granted only to the non-functional form of an object, and the patented design has to be novel and not obvious, considering the designs already on the market. The term of a design patent is only 14 years. In 1993, the Seventh Circuit decided that the configurations of sink faucets and faucet handles could be registered as a trademark, as a package or configuration of goods, Lanham Act 23, so this can be another avenue if a design patent is not available or not desirable, or if there was a design patent but its term has expired. In some ways, a patent is the most desirable type of intellectual property protection, because it is so absolute. A patent is a legal monopoly. During the term of the patent, no one except the patent holder and its licensees is allowed to practice the patent by using the process or manufacturing the invention that is covered by the patent. Even someone who independently discovers the same way to do the same thing, reverse engineering, won't be allowed to use it as long as the patent is design. Patents don't determine trade dress. According to a 1996 case from the Southern District of New York, the existence of a design patent is neutral in its effect on whether trade dress, configuration and packaging of a product, is protectable. The design patent neither guarantees nor rules out protection of trade dress using trademark-related concepts still in force, because all patents are registered and on display where the public can access detailed descriptions of the invention. Disclosure is an essential part of the patent system. On one level, it serves to protect the patent holder, because everyone is expected to perform patent searches to avoid infringement. On another level, it benefits the concept of the progress of general knowledge, because inventors and technicians can keep current on what has been invented, and they might get new ideas for improving on the prior art, the database of existing and expired patents, and making new inventions that, in turn, can be patented. However, as soon as the patent expires, anyone is allowed to take advantage of the information contained in the patent application. Most forms of intellectual property protection come into effect automatically, even without registration, although property owners' rights are greater in the case of registered intellectual property. In addition, the registration process is automatic in the case of copyrights, and most trademark applications achieve approval. In contrast, review of patent applications is lengthy, painstaking, and expensive for the applicant. Even once a patent has issued, the patent holder's life is not always smooth and easy. The owner may be embroiled in complex, expensive litigation against alleged infringers, or the validity of the patent may be challenged in court by others who claim that it infringes their patent, or that the patent should not have been issued in the first place. Comparing copyrights and trademarks. Sometimes it is hard to decide where copyright protection ends and trademark protection begins. This is especially true for series properties, example a series of mystery novels, a television show, or even movies that launch several sequels. The title of just one work can't be a trademark, but a series title can be, because, like all trademarks, it identifies the source. Furthermore, there may be protectable trademark rights in depiction of characters from fiction. As mentioned, the purpose of a trademark is to serve as a distinctive identifier of the source of goods. Designs used in a trademark must be non-functional. On the other hand, copyright protects original creative works of expression, including three-dimensional designs, as long as the form is not purely functional. One area of overlap comes from 102(a)(5) of the Federal Copyright Act. This section allows copyright registration of pictorial, graphic, and sculptural works, including labels and cartons, items that might also be defined as, or include, trademarks. The Copyright Office won't register labels or cartons unless they include copyrightable material. For instance, if the hang tag for Ed's lumberjack jackets included a story about how a lonely lumberjack spent his evenings sewing warm, sturdy jackets. Copyright registration will be denied if the material submitted for registration only includes trademark material and nothing that is entitled to copyright protection. A common law trademark lasts as long as the mark is in use. A federally registered trademark lasts for 10 years, and can be renewed for an indefinite number of additional 10-year terms as long as the mark is still in use. The term of copyright protection, for works copyrighted in or after 1978, is the author's lifetime plus 70 years. For a work for hire, the term is 95 years from the date of publication, or 120 years from the date of creation, whichever comes first. Section 101 of the Copyright Act sets out two categories of works for hire. The first is work done by an employee, as part of his or her job. The other category covers work that is specially ordered or commissioned as part of a collective work, such as an anthology of essays, or a movie made up of several shorts, translations, and supplementary works such as tests and teacher's guides for textbooks. A 1989 U.S. Supreme Court case says that the fee paid to an independent contractor, not an employee, who creates a work for hire only entitles the commissioning party to one-time use of the work. The creator would be entitled to extra compensation if the commissioning party wants to reuse the work, unless at the beginning of the transaction, the parties agreed to transfer all rights in the work in return for a one-time fee. You seen some word used above that referred you to the Deceptive Trade Practices Act. Here is some sections by state for more study. Revised Uniform Deceptive Trade Practices Act. Uniform Deceptive Trade Practices Act, 1964 Act or 1966 Revision, Colorado, 1966 Revision, 6-1-101 to 6-1-115 Delaware, 1964 Act, Del Code, Title 6, Subtitle 2, CH 25, Subchapter 3, 2531 to 2536 Georgia, 1966 Revision, 10-1-370 to 10-1-375 Hawaii, 1966 Revision, 481A1 to 481A5 Illinois, 1964 Act, Maine, 1964 Act, Minnesota, 1966 Revision, 325D.43 to 325D.48 Nebraska, 1966 Revision, 87 to 301 to 87 to 306 New Mexico, 1966 Revision, NM Statutes, Chapter 57, Art. 12 Ohio, 1966 Revision, Ohio Revised Code, Title 41, CH 4165 Oklahoma, 1964 Act, 7851-55 Oregon, 1966 Revision, 646.605 to 646.656. Patents. This chapter is one of the easiest to understand yet the most difficult to put in place. The reason is simple. Most people do not know the history of the land they are on. The next few pages are designed to help you understand how patents work and where they originally came from and what specifically they do and cannot do. The information comes straight out of 63 AAMJUR 2D 70-79. Please take time and read this part of the AMJUR so you have a great wealth of knowledge in this area before attempting any theories on land rights or protection. For the most comprehensive information on land, see the end of the section for the main source of all this section. Please read on for more. Outrands. Outrands is a Scottish word meaning mastery, control, making it an appropriate name for a new organization whose purpose is to teach the who, how, why, what, where and when based on historical and legal foundation principles of property ownership. Outrands' main objective is to keep the property owner out of the courtroom. The only logical way of accomplishing this is to make the property owner knowledgeable in property ownership and rights and to those laws the local, county, state or federal public servants shall rely upon. This teaching process is two-sided, meaning you will be required to work. Far too many people failed in protecting their property rights because they did not understand the proper use and application of their property rights. This continuing failure is based on one constant fact, the human nature of taking the easiest and cheapest course of action to protect their most valuable piece of property. People spend hundreds of dollars and several weeks or months out of their lives to purchase a piece of property. However, when ensnared in a property rights problem, they seek the cheapest magic silver bullet and then complain after they discovered it wasn't magical after all. Outrands will, at this immediate time, provide you with the following. A copy from that portion taken from an original late 18th century cyclopedia describing the colonization of North America, including the charters and land grants of the original colonies, the histories and laws of those colonies from their inception, and as well as the newly created states and United States. 1796, 455 pages. A copy of History of Public Land Law Development written for the Public Land Law Review Commission commencing from the beginnings of the United States. 1968, 425 pages. A copy of Commentaries on the Modern Law of Real Property, a legal treatise on foreign, state and United States land grants and patents, 1965, 120 pages. A copy of Restoration of Lost or Obliterated Corners and Subdivision of Section, a guide for surveyors written by Bureau of Land Management, 1974, 47 pages. A copy of Historical Highlights of Public Land Management written by U.S. Department of Interior commencing from the beginnings of the United States. 1962, 47 pages. A copy of Public Trust Doctrine in Natural Resource Law, a legal treatise for you to understand from whence the public servants come from. 1970, 48 pages. A copy of the Congressional Act, S, providing for the creation of the territorial government and thence the state your property is located in. If required, the treaty between the United States and the previous foreign nation that originally held possession of that land. Variable number of pages. A copy of your state's current annotated statutes pertaining to planning, zoning, signs, building codes, wetlands, woodlands, endangered species, navigable waters, historic districts, surveying, recordings of deeds and freedom of information requests. Variable from 650 to 1,250 pages. A copy of the Congressional Act or your state's legislative act providing for the conveyance of the land and issuance of the title. Note, based on 2A requirements. K copies of various state and federal court decisions showing the force and effect of the original land titles and those laws which existed at the time of its issuance. 12 to 24 plus court decisions, number dependent on who issued the original title and when issued. L copies of hundreds of U.S. Supreme Court case decision sites covering the following subjects: public lands, state, territories and possessions, cloud of title, deeds, fiction of law and zoning. 1789 to current, 391 pages new edition. To you, the property owner, will provide Outrands with the following material. A copy of the complete abstract of title for your property for its review to determine whether there are any breaks in the chain of title back to the original land title regardless of its origin and source. With that abstract, our ANS can advise you who to contact in order to obtain a certified copy of that original title, the official land survey and the surveyor's field notes. When you receive those certified records, you will copy same and ship it to our ANS for its archive files. Obtain a copy of your local governmental, be it township, village, city, or county, corporation's ordinances pertaining to I.H. above and ship it to our ANS for its review and archive files. Note that our ANS cannot obtain such information from any legal source located in Michigan. 3. Our ANS plans in the near future, based on how many society members utilize our service, to obtain the following. This has been put on hold due to lack of funding and customers. Brief summary for basis as to why perform a title search. Abstract. The United States of America never had, or held, sovereignty, proprietary title, public trust, public interest, control, or jurisdiction to, over and of the lands within the New England and Atlantic coast states, excepting Florida or Pennsylvania, West Virginia, Kentucky, Tennessee and Texas. The only exception being those lands which any state ceded total, partial, or concurrent legislative jurisdiction, title, interest and control to the United States through their respective legislative acts. Excluding the founding states and Texas, all other states entered into the Union came from territories acquired by the United States of America either from the founding state cession of lands, outright purchase, or treaty obligations from foreign national governments. Congress, empowered by Article 4, Sector 3, CL 2 of the Constitution, enters new states into the Union out of the public domain. These states are public land states and are given certain powers, duties, and responsibilities per compacts, contracts, identified as enabling acts that Congress passes into law, statutes at large. Within some of these public land states there exists land that had already conveyed into private ownership, prior to that territory's acquisition by the United States of America, either from a previous foreign nation or one of the original founding states. Congress by authority of Article 4, Sector 3, CI 2 of the National Constitution passed hundreds of acts to dispose of land from the public domain or, to confirm titles called private land claims issued by a foreign government. Today someone is buying land out of the public domain from the United States and title to that land will be a United States of America land patent. That land patent is issued to the original purchaser, the patentee, his/her heirs or assigns whoever else buys that land forever. All rights, privileges, immunities, and appurtenances of whatsoever nature as stated in the Congressional Act and patent became vested to the patentee, his/her heirs and the assigns on the date of purchase by the patentee. Once the land patent issues, no one, including the grantor, the grantee, an heir or an assign can change the patent. The highest evidence of title for the possession, use, and enjoyment of land, as determined by 200+ years of American jurisprudence, is a land grant or patent, issued either by a previous foreign government, a state, or the United States of America. The land grant or patent is conclusive evidence against all persons whose rights did not commence previously and against those persons not in privity with the paramount source of the title. The only laws applicable to land are laws that existed at the time when title was issued. This applies to foreign royal charter, land grant, or patent, of founding states, a public land states or a United States of America land grant or patent issued at any time. Current public policy, statutes, ordinances, administrative rules or regulations, legal definitions of words or phrases are not applicable. What is the intent of the phrase the patentee, his heirs, and assigns? That was determined by the U.S. Supreme Court in Delhi Vernier Refrigeration Machine Co. v. Featherstone, 147 U.S. 209. The word heirs in a patent should not be regarded as defining the extent of the patentee's own interest. It is not used in a technical sense, but indicates the persons who are to have the benefit of the invention in the event of the patentee's death. The absolute character of the interest of the patentee is not attributable to the word. The words of the statute, the patentee, his heirs, and assignee, whether constructed according to the rules of grammar or to the intent of Congress, mean the patentee, his heirs, or assigns. They comprehend the legal representatives, assigns in law, and assigns in fact, and the phraseology raises no limitation in the strict common law rule applied to realty. Naturally, the obvious question you now ask is, what is my first step to take? First you need to locate the original title to land you intend to buy or already own by doing a title search. Abstract. 1. If the land is located in a public land state, you look up the legal description original U.S. government survey usually listed in your deed, mortgage papers, or property tax statement. It will look similar to this: Serfdom Acres Subdivision Number 1, Lot number 6, located in the southeast quarter of the northwest fractional quarter of Section 10 in Township T4 NR6E. 2. If the land is located in one of the founding states, Texas, West Virginia, Kentucky or Tennessee, the legal description usually listed in those documents as referenced above may be described in what is called metes and bounds. Whereas, the legal description will be based on either a foreign nation's or that state's survey and look similar to this, beginning at the large oak, then running west for 2,000 rods to a large boulder, then southwesterly for 1,500 rods to a creek, then easterly along said creek for 3,000 rods to the point of beginning. Note in the original founding states original titles to land, especially located immediately in or near 250 to 350-year-old cities, i.e., New York City, Salem, Pittsburgh, Philadelphia, St. Augustine, etc., the chances are the original titles emanated from a European nation. Example, New York City, the title could be from Holland or England, if not then it would come from the state of New York. For West Virginia, Kentucky or Tennessee the original title could be from England, Virginia or the respective state itself. For Texas the original titles could be from Spain, Mexico, or Texas. For Florida, a public land state, the original titles could be from Spain, England, the United States of America or Florida. I can't go into exact detail for each of the 50 states or the various territories. Note, in some county register of deeds offices land titles are recorded either by grantor/grantee listings, which means the grantor is the seller and the grantee is the buyer, or by tract index, which always deals with the specific legal description by on the original surveys. Also, be advised that one county register of deeds office may record by grantor/grantee while a neighboring county register of deeds office may record by tract index. Now that you've located the original title, you need to progressively work on up in history to determine that there was no break in the chain of title from that time to the present. 1. The reason for this is to make sure that you, if you already own the land, do not merely hold a color of title, which is also called a marketable title. Color of means it looks, acts, feels and smells like the real McCoy but isn't, it only has the appearance of the real McCoy. Marketable means that if someone is willing to buy it even if it's worthless, then it's marketable. Similar to buying my interest in the Brooklyn Bridge and then recording it. If the county where the subject land is located uses the tract index method of recording, you can progressively work your way up in time to the present, just like reading a book. If the county where the subject land is located uses the grantor/grantee method of recording, then it's generally easier to work backwards in time, from the present backwards. Remember, the first step you take is to perform an abstract, or title search, on your existing or on property you plan on purchasing. Until that is done, you will merely be guessing and assuming as to what your property rights are. Our Ans and Y abstract written by and for more information contact, David Wilbur Johnson C/04175 Clintonville Road, Waterford, Michigan 48329, phone 248-674-2418, fax 877-897-4111, email davidwilburjohnson@juno.com. 9. UCC forms and how they work. There are only a few UCC documents to speak of, and they are relatively simple when put in an easy format. The UCC has, UCC1, an original UCC form used on a first-time filing of the creation of interests. UCC3 changes an original UCC1 in any way, rather delete, change, or adds. UCC5, a correction form used by either a debtor or secured party to correct a 1. UCC11 used to perform searches for property. Search is done in debtor's name. In order to understand this better, you first must understand that a UCC 1 or 3 by itself does nothing except for put the public on notice of an underlying agreement that created a security interest. If you do not have an underlying agreement, a security agreement, you have done nothing except pay the UCC unit for a filing that proves, attaches, and perfects nothing. A security agreement is defined as UCC 9 to 102. 73. Security agreement means an agreement that creates or provides for a security interest. Now the ABCs of the UCC revised Article 9 on page 18 reads: a security agreement is an agreement in which the debtor transfers a security interest in the collateral to the secured party. 9-102, a. 73. Thus, it is simply the consensual creation of a property interest. For most security agreements, attachment requires that the debtor authenticate a security agreement containing a description of the collateral. Also within the security agreement there are rules. There are 3 rules. The rules are: 1. The parties have an adequate security agreement. 2. The secured party gives value, and 3. The debtor has rights or the power to transfer rights, in the collateral. 9-203, b. The only other rules that apply are that on the UCC forms themselves that the debtor and secured party contact information must be clearly identifiable on the UCC forms and that proper filing fees be sent in order for filing. See UCC 9-516 and 9-520. Before even looking at the forms, you must understand there are rules for filing. These rules can be found in Article 9 at sections 9-516-9-520. 9-516. What constitutes filing? Effectiveness of filing. Names of both parties, legible, and the correct filing amount received. 9-517. Effect of indexing errors. If they make a mistake, it will not impair the agreement. Again, the security agreement supersedes the UCC notice. 9-518. Claim concerning inaccurate or wrongfully filed record. UCC 5 correction statements. 9-519. Numbering, maintaining, and indexing records, communicating information provided in records, UCC office duties with numbering etc. of UCC filings, 9-520. Acceptance and refusal to accept record. A. Mandatory refusal to accept record. A filing office shall refuse to accept a record for filing for a reason set forth in section 9-516, b, and may refuse to accept a record for filing only for a reason set forth in section 9-516, b, 9-516. What constitutes filing? Effectiveness of filing. A. What constitutes filing? Except as otherwise provided in subsection, b, communication of a record to a filing office and tender of the filing fee or acceptance of the record by the filing office constitutes filing. b. Refusal to accept record, filing does not occur. Filing, not effectiveness, does not occur with respect to a record that a filing office refuses to accept because 1. The record is not communicated by a method or medium of communication authorized by the filing office. 2. An amount equal to or greater than the applicable filing fee is not tendered. 3. The filing office is unable to index the record because a. In the case of an initial financing statement, the record does not provide a name for the debtor. b. In the case of an amendment or correction statement, the record I. Does not identify the initial financing statement as required by section 9-512 or 9-518, as applicable, or 2. Identifies an initial financing statement whose effectiveness has lapsed under section 9-515. c. In the case of an initial financing statement that provides the name of a debtor identified as an individual or an amendment that provides a name of a debtor identified as an individual which was not previously provided in the financing statement to which the record relates, the record does not identify the debtor's last name, or d. In the case of a record filed or recorded in the filing office described in section 9-501, a. 1. The record does not provide a sufficient description of the real property to which it relates. 4. In the case of an initial financing statement or an amendment that adds a secured party of record, the record does not provide a name and mailing address for the secured party of record. 5. In the case of an initial financing statement or an amendment that provides a name of a debtor which was not previously provided in the financing statement to which the amendment relates, the record does not a. Provide a mailing address for the debtor. b. Indicate whether the debtor is an individual or an organization, or c. If the financing statement indicates that the debtor is an organization, provide I. A type of organization for the debtor. 2. A jurisdiction of organization for the debtor, or 3. An organizational identification number for the debtor or indicate that the debtor has none. Now 9-517 I think is the most interesting. Read on, 9-517. Effect of indexing errors. The failure of the filing office to index a record correctly does not affect the effectiveness of the filed record. If they make a mistake, it is not your fault, nor does it render a filing void. Hence a filing need not be in place to be effective to begin with. Fixture filings. A fixture filing covers goods that are permanently attached to the land or real property. Fixture filings are recorded at a county register of deeds office. With this in mind, remember that a UCC filing itself is nothing more than a notice of an underlying agreement. The agreement is the power, not the UCC notice. This also proves that even if the UCC office does not record the UCC, the agreement is still effective, taking us to the fact that the agreement supersedes the state and the power to contract rests with the people. In Michigan, it's Article 1 Section 10 of the state constitution. Keep in mind also that security agreements do not cover future advances automatically, the parties must agree to this provision. Here is some good information from the UCC unit in Michigan for compliance rule when submitting any UCC filing. Please check your state for its rules and adoption. http://www.michigan.gov/sos/0,160/7-127-163-1_1629885-160.885-00.html Reasons for rejecting UCC filings. Uniform Commercial Code, UCC, Tips on Trouble-Free Filings. UCC 1 and UCC 3 filings can be rejected for a number of reasons. Under revised Article 9, it is the responsibility of filers to ensure their forms are complete and accurate. To ensure your filing is processed properly, please note the following. Potential reasons for rejecting UCC 1 filings. 1. No debtor last name, missing or incomplete address. 2. No secured party name, missing or incomplete address. 3. Submitted in an unacceptable medium. 4. No minimum correct fee. 5. Account number missing. 6. Illegible writing. 7. Debtor is not identified as either an individual or organization. 8. No assignee name or address if applicable. Assignee should be listed on the UCC1 and the original secured party name should be listed on the UCC1 addendum. 9. Debtor organization type, jurisdiction, or identification number is missing. If there is no identification number, type none. Potential reasons for rejecting UCC 3 filings. 1. Debtor name or address incomplete or missing when processing a name or address change. 2. Assignee name, address and secure party name are missing when processing an assignment. 3. Submitted in an unacceptable medium. 4. No minimum correct fee. 5. Account number missing. 6. Illegible writing. 7. Debtor is not identified as either an individual or organization. 8. Not continued within 6 months prior to lapse. 9. Original file number is missing. 10. Original filing has lapsed or expired. 11. Debtor organization type, jurisdiction, or identification number is missing. When changing the debtor name, if there is no identification number, type none. Also here is an update for those who say County Register of Deeds do not file. http://www.michigan.gov/documents/UCC_update_17966_7.pdf. Under revised Article 9, Section 9501 of the Uniform Commercial Code, UCC, the following financing statements are filed at Register of Deeds offices, land and property. As long as it is in the county where the lands are. As extracted collateral. Timber to be cut. Fixtures. Existing records of financing statements filed before July 1, 2001 are still maintained at the county. Secured parties who are filing Section 9706 in lieu of financing statements with the state need access to these records. This access also allows searchers to determine the correct status of documents previously filed with the county. As of July 1, 2001, records of financing statements no longer filed at the county still need to be maintained for 1 year past the lapse date or until July 1, 2007, whichever is sooner. Unless an in lieu of financing statement has been filed under Section 9706, termination is made at the County Register of Deeds office. Revised Article 9 does not change the location for terminating financing statements. Financing statements filed with the County Register of Deeds before July 1, 2001, or for the 3 types of collateral stated above, may still be terminated at the County Register of Deeds. The fee for a termination statement is now $10 for the first 2 debtor names listed. Each additional debtor name is an additional $10. Register of Deeds offices still accept certain financing statements and terminations. As authorized by revised Article 9, Section 9707, 5, a financing statement filed at the county office before July 1, 2001 can be terminated at the county office. Register of Deeds offices still accept a termination statement referencing the original county filing number. Recording these terminations is critical to providing an accurate status for the collateral involved in the filing. The state UCC office cannot directly terminate the county filing when the original financing statement is not filed with the state. Terminating a financing statement at the state office requires the secured party to file an in lieu of UCC1 financing statement before a UCC3 financing statement to terminate. If a secured party files an in lieu of UCC1 with the state then later files a termination statement on the previous financing statement at the County Register of Deeds office, the state in lieu of financing statement remains effective. The purpose of the in lieu of financing statement is to continue or amend a financing statement filed with the county office before July 1, 2001. The in lieu of filing establishes or perfects the secured interests at the state UCC office. When an in lieu of financing statement is filed, it is assigned a new initial filing number. Any continuations or amendments at the state UCC office must reference the state-issued initial filing number. Financing statement terminations and in lieu of filings of. With the enactment of revised Article 9 on July 1, 2001, rules and procedures were changed concerning the filing of financing statements. Following are some of the most common errors made when filing financing statements, and what to do to avoid these errors. Filing financial statements, avoiding common filing errors, omitting UCC1 organization information. On filing statements, naming an organization as the debtor, the organization type, jurisdiction, and organization identification number are frequently incomplete or missing from the financing statement. All three fields must be completed on organization financing statements. On the UCC1 financing statement, complete the organization type, jurisdiction, and identification number, items 1E, 1F and 1G, respectively. And type, jurisdiction, and identification number, items 1E, 1F and 1G, respectively. Omitting a UCC3 organization information. When adding or changing a debtor name, complete a UCC3 financing statement amendment. If the debtor is an organization, complete the organization type, jurisdiction, and identification number, items 7E, 7F and 7G, respectively. To verify debtor organization information, contact the Michigan Department of Consumer and Industry Services at www.cis.state.mi.us/bcs/corp. Now the most important part of any UCC filing is its underlying agreement. The notice, UCC filing, only states there is an underlying agreement. Without an underlying agreement, the UCC filing means nothing. Remember, a security agreement is defined as 9-102(73). Security agreement means an agreement that creates or provides for a security interest. Now, in order for a security agreement to be effective, there are three rules. 1. The debtor must transfer a property, collateral, or a right to a property or collateral to the secured part. If the debtor cannot prove ownership or a right to the property or collateral, then the filing, no matter the terms or wording, any filing is not effective by its own lack of authority or right. 2. Another requirement is that the collateral be specific in nature. Not just super generic words. i.e., all property is not effective. It must adequately describe the property or collateral. It must be clearly and specifically described so as to draw no confusion for other property or collateral. This eliminates false claims by ambiguous description of properties. 3. The last requirement is that the secured party must give value, consideration, for the property or right to or in property. 1-201-44, value. Except as otherwise provided with respect to negotiable instruments and bank collections, Sections 3-303, 4-208 and 4-209, a person gives value for rights if he acquires them. A. In return for a binding commitment to extend credit or for the extension of immediately available credit, whether or not drawn upon and whether or not a chargeback is provided for in the event of difficulties in collection, or B. As security for or in total or partial satisfaction of a pre-existing claim, or C. By accepting delivery pursuant to a pre-existing contract for purchase, or D. Generally, in return for any consideration sufficient to support a simple contract. 3-303. Value and consideration. A. An instrument is issued or transferred for value if 1. The instrument is issued or transferred for a promise of performance, to the extent the promise has been performed. 2. The transferee acquires a security interest or other lien in the instrument other than a lien obtained by judicial proceeding. 3. The instrument is issued or transferred as payment of, or as security for, an antecedent claim against any person, whether or not the claim is due. 4. The instrument is issued or transferred in exchange for a negotiable instrument, or 5. The instrument is issued or transferred in exchange for the incurring of an irrevocable obligation to a third party by the person taking the instrument. B. Consideration means any consideration sufficient to support a simple contract. The drawer or maker of an instrument has a defense if the instrument is issued without consideration. If an instrument is issued for a promise of performance, the issuer has a defense to the extent performance of the promise is due and the promise has not been performed. If an instrument is issued for value as stated in subsection A, the instrument is also issued for consideration. 4 to 104, 8, drawee means a person ordered in a draft to make payment, this is you. 4 to 208. Presentment warranties. A. If an unaccepted draft is presented to the drawee for payment or acceptance and the drawee pays or accepts the draft, I, the person obtaining payment or acceptance, at the time of presentment, and, 2, a previous transferor of the draft, at the time of transfer, warrant to the drawee that pays or accepts the draft in good faith that 1. The warrantor is, or was, at the time the warrantor transferred the draft, a person entitled to enforce the draft or authorized to obtain payment or acceptance of the draft on behalf of a person entitled to enforce the draft. 2. The draft has not been altered, and 3. The warrantor has no knowledge that the signature of the purported drawer of the draft is unauthorized. B. A drawee making payment may recover from a warrantor damages for breach of warranty equal to the amount paid by the drawee less the amount the drawee received or is entitled to receive from the drawer because of the payment. In addition, the drawee is entitled to compensation for expenses and loss of interest resulting from the breach. The right of the drawee to recover damages under this subsection is not affected by any failure of the drawee to exercise ordinary care in making payment. If the drawee accepts the draft, I, breach of warranty is a defense to the obligation of the acceptor, and, 2, if the acceptor makes payment with respect to the draft, the acceptor is entitled to recover from a warrantor for breach of warranty the amounts stated in this subsection. C. If a drawee asserts a claim for breach of warranty under subsection A, based on an unauthorized endorsement of the draft or an alteration of the draft, the warrantor may defend by proving that the endorsement is effective under section 3 to 404 or 3 to 405 or the drawer is precluded under section 3 to 406 or 4 to 406 from asserting against the drawee the unauthorized endorsement or alteration. D. If I, a dishonored draft is presented for payment to the drawer or an indexer or, 2, any other item is presented for payment to a party obliged to pay the item, and the item is paid, the person obtaining payment and a prior transferor of the item warrant to the person making payment in good faith that the warrantor is, or was, at the time the warrantor transferred the item, a person entitled to enforce the item or authorized to obtain payment on behalf of a person entitled to enforce the item. The person making payment may recover from any warrantor for breach of warranty an amount equal to the amount paid plus expenses and loss of interest resulting from the breach. E. The warranties stated in subsections A and D cannot be disclaimed with respect to checks. Unless notice of a claim for breach of warranty is given to the warrantor within 30 days after the claimant has reason to know of the breach and the identity of the warrantor is discharged to the extent of any loss caused by the delay in giving notice of the claim. F. A cause of action for breach of warranty under this section accrues when the claimant has reason to know of the breach. 4 to 209. Encoding and retention warranties. A. A person who encodes information on or with respect to an item after issue warrants to any subsequent collecting bank and to the payer bank or other payer that the information is correctly encoded. If the customer of a depository bank encodes, that bank also makes the warranty. B. A person who undertakes to retain an item pursuant to an agreement for electronic presentment warrants to any subsequent collecting bank and to the payer bank or other payer that retention and presentment of the item comply with the agreement. If a customer of a depository bank undertakes to retain an item, that bank also makes this warranty. C. A person to whom warranties are made under this section and who took the item in good faith may recover from the warrantor as damages for breach of warranty an amount equal to the loss suffered as a result of the breach, plus expenses and loss of interest incurred as a result of the breach. Once these three things are done and done correctly in accordance with the filing office requirements in 9-516-9-520, the UCC office will give minimal problems. Now for some general questions and answers covering this section. Source: http://www.michigan.gov/sos/0,1607,7-127-5-127-5-5-F,00.html number sign 65 Michigan Secretary of State UCC Unit. What is the purpose of Uniform Commercial Code? Answer: the Uniform Commercial Code, or UCC, as it is commonly abbreviated, provides a central location for filing a public notice of a secured transaction. This notice, called a financing statement, is evidence of a commercial agreement between two parties, called the debtor and secured party. The department's UCC office, upon request, also searches the filed information by name. When a business applicant pledges collateral on a loan, UCC search results tell lenders whether others have filed a claim against the same collateral. What is a financing statement? Answer. A financing statement is an initial financing statement and all UCC documents that relate to the initial financing statement. An initial financing statement was formerly called an original financing statement. A financing statement is filed to perfect a security interest and provide a public notice of a security agreement between a debtor and a secured party. The financing statement describes certain types of collateral or property used as surety for the security agreement. What forms do you accept for filing? Answer. The National UCC-1 Financing Statement Form and the National UCC-3 Financing Statement Amendment Form, with revision dates of May 22, 2002, are the standard filing forms used. Where should I file a UCC financing statement? Answer. The Uniform Commercial Code designates where to file based on the type of collateral. Effective July 1, 2001, the collateral location no longer determines where to file. Filings for organizations are made in the state where the organization is registered. Filings for individuals are made in the state of residence. Filing in the wrong office is not a rejection reason. Listed in the statute. Are signatures required on an initial financing statement? Answer. Effective July 1, 2001, signatures are no longer required on an initial financing statement. Is a tax identification number required for a filing? Answer. Effective July 1, 2001, a tax identification number is no longer required on initial and amendment financing statements. Who determines the types of collateral included on a financing statement? Answer. This decision is left to the filer. Mortgages, fixtures, minerals, and timber to be cut are filed with the County Register of Deeds. Filing in the wrong office is not a rejection reason listed in the statute. All other types of collateral, including filings for transmitting utilities, should be filed with the state UCC unit. How long is a financing statement active? Answer. If a continuation is not filed, the financing statement will lapse 5 years from the original filing date. A continuation extends the filing period 5 additional years from the initial filing date. Subsequent continuations may be filed in increments of 5 years and always expire on the anniversary date of the initial filing. A continuation may be filed up to 6 months before the expiration date of the financing statement. Under revised Article 9, all lapsed and terminated filings remain active for search reporting purposes until 1 year after the initial financing lapses or would have lapsed. D. Have lapsed. How do I terminate a financing statement? Answer. Terminate the financing statement in the office where the original financing statement was filed. If the original was filed with the state UCC office, terminate at the state UCC office. Likewise, if the original was filed with the County Register of Deeds, terminate at the County Register of Deeds. What is a fixture filing? Answer. A fixture filing covers goods that are permanently attached to the land or real property. Fixture filings are recorded at a County Register of Deeds office. Crops growing or to be grown are not fixtures, and are filed at the UCC office. What is the purpose of the correction statement? Answer. A correction statement may be filed by the debtor, not secured interests, if it is believed that a particular record is inaccurate or was wrongfully filed. The filing of a correction statement does not affect the effectiveness of a previously filed document. The UCC office files the correction statement with the initial filing, but no information in the initial filing is changed. The UCC office does not determine whether the correction statement is effective or legitimate. A financing statement amendment must be used to make changes on previous filings. How do I change a county filing to the state UCC office? Answer. File an in lieu of initial financing statement with the state UCC office, in place of filing a continuation or other amendment financing statement, UCC-3, at the County Register of Deeds office. Complete a UCC-1 with current information for debtors, secured parties, and collateral. An in lieu of filing may either list file numbers or include copies of multiple initial financing statements and corresponding amendment financing statements for the same debtor. The secured party determines whether or not to file an in lieu of filing. What form is used to request a search of UCC filings? Answer. The UCC-11 form is the approved form to request information and/or copies. State the debtor name you wish to search. Debtor names will be searched exactly as they were provided by the requester. Also state whether you need an information listing of financing statements and tax liens, copies of the documents or both. The information listing does not provide information about collateral shown on financing statements. XUCC State Status and Contact Information. Revised UCC Article 9 State Status as of July 2, 2001. State or Jurisdiction 51 of 51 enacted effective July 1, 2001 4 with non-uniform effective dates Alabama yes January 1, 2002 Alaska yes Arizona yes Arkansas yes California yes Colorado yes Connecticut yes October 1, 2001 Delaware yes District of Columbia yes Florida yes January 1, 2002 Georgia yes Hawaii yes Idaho yes Illinois yes Indiana yes Iowa yes Kansas yes Kentucky yes Louisiana yes Maine yes Maryland yes Massachusetts yes Michigan yes Minnesota yes Mississippi yes January 1, 2002 Missouri yes Montana yes Nebraska yes Nevada yes New Hampshire yes New Jersey yes New Mexico yes New York yes North Carolina yes North Dakota yes Ohio yes Oklahoma yes Oregon yes Pennsylvania yes Rhode Island yes South Carolina yes South Dakota yes Tennessee yes Texas yes Utah yes Vermont yes Virginia yes Washington yes West Virginia yes Wisconsin yes Wyoming yes Alabama. Secretary of State, UCC Section PO Box 5616, Montgomery, Alabama 36103 5616 Phone 334-242-5231. Alaska. State of Alaska UCC Central File System Department of Natural Resources Support Services Division 3601 C Street, Suite 1140A Anchorage, Alaska 99503-5947. Arizona. Secretary of State, UCC Department Capitol West Wing, 7th floor 1700 West Washington Avenue, Phoenix, Arizona 85007 Phone 602-542-6187. Arkansas. Secretary of State, UCC Division State Capitol, Room 025 Little Rock, Arkansas 72201-1094 Phone 501-682-5078. California. Secretary of State, UCC Division PO Box 942835 Sacramento CA 942835 Sacramento, California 94235-0001 Phone 916-653-3516. Colorado. Secretary of State, UCC Division 1560 Broadway, Suite 200 Denver, Colorado 80202-5169 Phone 303-894-2200, Press 3. Connecticut. Secretary of State, UCC Unit 30 Trinity Street, EET, Hartford, Connecticut 06106 Phone 860-509-6004. Delaware. Secretary of State DIV of Corporations UCC Section PO Box 793 Dover, Delaware 19903 Phone 302-739-4270. District of Columbia. Recorder of Deeds of the District 515 D Street NW, Room 202 Washington, D.C. 20001 Phone 202-727-5190. 202-727-5189. Florida. Department of State UCC Filings Bureau of Commercial Recordings PO Box 5588 Tallahassee, Florida 32314 Phone 850-487-6055. Georgia. Filing may done with the clerk at the Superior Court of each county, do not file with the Secretary of State. Phone 404-327-9058. Hawaii. Department of Land and Natural Resources Bureau of Conveyances PO Box 2867 Honolulu, Hawaii 96803 Phone 808-587-0134. Idaho. Secretary of State, UCC Division PO Box 83720 700 West Jefferson, Boise, Idaho 83720-0080 Phone 208-334-3191. Illinois. Secretary of State, UCC Division Howlett Building, Room 32nd and Edward St. Springfield, Illinois 62756 Phone 217-782-7518. Indiana. Secretary of State, UCC Division 018302, Washington Street West Est, Indianapolis, Indiana, 46204. Phone, 317-232-6518. Iowa. Secretary of State, UCC Division Hoover Building, East 14th and Walnut, St. Des Moines, Iowa, 50319. Phone, 515-281-5204. Kansas. Secretary of State, UCC Division The State Capitol Building, 2nd floor, 300 Southwest 10th Street, Topeka, Kansas, 66612-1594. Phone, 785-296-4564. Kentucky. Secretary of State, UCC Division 700 Capitol Street, Suite 86, State Capitol Building, Frankfort, Kentucky, 40601-3493. Phone, 502-564-2848. Louisiana. Filing may done with the clerk of the court in each parish, do not file with the Secretary of State. Phone, 504-922-1314. Maine. Secretary of State, UCC Filing Section, Bureau of Corporations and Elections, State Office Building, Room 221-101, State House Station, Augusta, Maine, 04333-0101. Phone, 207-287-4177. Maryland. Department of Assessments and Taxation, 301 West Preston Street, Room 809, Baltimore, Maryland, 21201-1459. Phone, 44 Department of Assessments and Taxation, 301 West Preston Street, Room 809, Baltimore, Maryland, 21201-1459. Phone, 410-767-1179. Massachusetts. Secretary of State, UCC Division 1 Ashburton Place, Room 1711, Boston, Massachusetts, 02108. Phone, 617-727-2860. Michigan. Michigan Department of State, UCC Unit PO Box 30197, Lansing, Michigan, 48909-7697. Phone, 517-322-1144. Minnesota. Secretary of State, UCC Division 180, State Office Building, 100 Constitution Avenue, St. Paul, Minnesota, 55155-1299. Phone, 651-296-2803. Mississippi. Secretary of State Business Services, DIV, UCC DIV PO Box 136, Jackson, Mississippi, 93205-0136. Phone, 601-359-1633. Missouri. Secretary of State, UCC Division 600, West Main Street, Room 302, Jefferson City, Missouri, 65101. Phone, 573-751-2360. Montana. Secretary of State Business Services Bureau PO Box 202-801, Helena, Montana, 59620-2801. Phone, 406-444-3665. Nebraska. Secretary of State, UCC Division 1305, State Capitol Building, PO Box 95104, Lincoln, Nebraska, 68509. Phone, 402-471-4080. Nevada. Secretary of State, UCC Division North Carson Street, Number 3, Carson City, Nevada, 89701-4786. Phone, 702-687-5203. New Hampshire. Secretary of State, UCC Section Room 204, State House 107, North Main Street, Concord, New Hampshire, 03301. Phone, 603-271-3276. New Jersey. Department of Revenue Central Filing, UCC Section Box 303, Trenton, New Jersey, 08625. Phone, 609-530-6426. New Mexico. Secretary of State, UCC Division State Capitol Building, Room 420, Santa Fe, New Mexico, 87501. Phone, 505-827-3600. New York. New York Department of State, 41 State Street, Albany, New York, 12231. Phone, 518-747-5418. North Carolina. Secretary of State, UCC Division 300, North Salisbury Street, Room 302, Raleigh, North Carolina, 27546. Phone, 919-733-4205. North Dakota. Secretary of State, UCC Division Capitol Building, First floor 600 East Boulevard Avenue Department 108 Bismarck, North Dakota 58505-0500 phone 701-328-3662. Ohio. Secretary of State, UCC Division 30 East Broad Street State Office Tower, 14th floor Columbus, Ohio 43266-0416 phone 614-466-3623. Oklahoma. Oklahoma Central Filing Office 320 Robert S. Kerr Avenue, STE 107 Oklahoma City, Oklahoma 73102 phone 405-713-1522. Oregon. Oregon Secretary of State Corporation Division UCC Section Public Service Building 255 Capitol Street NE, STE 151 Salem, Oregon 97310-1327 phone 503-986-2200. Pennsylvania. Pennsylvania Department of State Corporation Bureau, UCC Section PO Box 8721, Harrisburg, Pennsylvania 17105-8721 phone 717-787-1057. Rhode Island. Secretary of State, UCC Division 100 North Main Street, Providence, Rhode Island 02903 phone 401-222-3040. South Carolina. Secretary of State, UCC Division PO Box 11350, Columbia, South Carolina 29211 phone 803-734-2170. South Dakota. Secretary of State, UCC Division Central Filing 500E Capital Pierre, South Dakota 57501-5077 phone 605-773-4550. Tennessee. Secretary of State, DIV of Business Services James K. Polk Building, STE 1800505, Dedrick Street, Nashville, Tennessee 37243-0306 phone 615-741-3276. Texas. Secretary of State, UCC Division PO Box 13193, Austin, Texas 78711-3193 phone 512-475-2703. Utah. State of Utah, UCC Division PO Box 146705, Salt Lake City, Utah 84114-6705 phone 801-530-4849. Vermont. Secretary of State, UCC Division 109, State Street, Montpelier, Vermont 05609-1104 phone 802-828-2386. Virginia. State Corporation Commission, Clerk's Office PO Box 1197, Richmond, Virginia 23218-1197 phone 804-371-9733. Virgin Islands. Office of Lieutenant Governor PO Box 450, Corporation UCC Division Charlotte Amalie, St. Thomas, Virgin Islands 00802 phone 809-774-2991. Washington. Department of Licensing, UCC Section PO Box 9660, Olympia, Washington 98507-9660 phone 360-664-1530. West Virginia. Secretary of State, UCC Department, State Capitol Building, Room W131 900, Kanawha Boulevard, East Charleston, West Virginia 25305 phone 304-558-6000. Wisconsin. Wisconsin Department of Financial Institutions, UCC Division PO Box 7847, Madison, Wisconsin 53707-7847 phone 608-261-9548. Wyoming. Secretary of State, UCC Division Capitol Building, Room 110, Cheyenne, Wyoming 82022-0020 phone 307-777-5372, 5334, or 5342. This has been a production by The Mental Chemist, for study and education. Copyright 2024.